Hi everyone, I'm Kevin Perteete, and I want to thank you for joining me for my video lecture workshop entitled We the Slave Contract People of America. First thing I need to tell you is that I'm not a lawyer, and this is not to be taken as legal advice. Anything that you use so on your own accord or your own free will. I'm not liable for that, and that's a legal disclosure or disclaimer that I have to state in order to protect myself. I hate to have to do that, but that's the way the times and things are nowadays. The next thing I want to tell you is, why am I doing this? I'm doing this because I'm tired of still hearing people say things like, you have to pay taxes, who's going to pay for the roads, who's going to pay for this and that. What do you mean we're not free people? This is America, land of the free. All of that stuff. And I'm tired of going down to these courts and dealing with these sociopathic judges yelling and screaming over nothing, over some minor moving violation or whatever, and they act like you've committed the most heinous murder crime in history or something, the way that they talk down to you. And it's just downright disrespectful. And I'm going to explain to you what they think of us later on in this video on that. But I simply want to let them know, I know who you are, what you are, where you are, what you're doing, what you've been doing, what you plan to do in the future. And it's just a stand-up for me to let these people know. And when I say these people, I'm speaking of the Illuminati, Freemasons, the international bankers, the New World Order people, whoever you want to call them, I guess. So, at any rate, that's that. The next thing I want to share with you is explaining to you that this lecture workshop is going to be broken down into parts. And I don't know how long. I'm doing this all live. It could be 3, 4, 5 hours long. I don't know. And I'm making up the titles or parts as I go and so forth. But it's going to cover quite a bit. And I know that I'm going to be talking about word meanings, U.S. citizenship versus state citizenship, Social Security, U.C.C. code, taxes, and then of course the last part is going to deal with how to exempt yourself from paying taxes out of your paychecks and what forms you would use instead of a W-4 form, etc. So that's the way that's going to go. And I want to also tell you to please forgive me if you hear dogs barking and airplanes and loud noises and so forth. I wanted to make this video much more professional and secure, like a classroom, and have like a chalkboard or writing board behind me, what have you. I wasn't able to secure that in time, so I have to do it in my home, and you're going to hear those sounds. I apologize. Also, too, I'm going to probably butcher some words, or my throat's going to get dry and crackly and stuff, so that's going to happen. I already know it. And I'm going to try to come back and, repronounce the word in the next chapter or next part if I can, if I remember to. And also too, sometimes I get ahead of myself and I do not complete sentences. I'm aware of that, and I know that I do that. And like I said, I'm apologizing to you ahead of time about those things, and I'm going to try to correct them or stay on top of them as best I can. I'm basically a one-man unit, guys. My video quality and all that, I don't know how it's going to look. And like I said, I apologize. I won't even know till it's done, edited, and uploaded, and so forth. I do the best that I can with the little knowledge I have on this stuff. And it's much better than it was when I first started. So, bear with me on all that. Like I said, this is just a small introduction. I just want to explain to you what's going on and all of that type of stuff. Another thing is, keep in mind that some of the information that I will be sharing with you is probably, I won't say outdated, but laws, codes, and things like that change frequently, as you know. And like a lot of stuff that I have is older information. I still feel and believe that it's going to be very valuable for you to hear this, what I have, because I've never heard anyone, a couple people, but most people I don't think are aware of some of the things I'm going to share with you. And so it's still valid. But just some things that have changed in codes and the law, whatever. You can correct me. I have no problems or quorums with you doing that. And I would appreciate that you do that, because we want to try to keep on top of it always. And I want to share with you really quickly 2 things that I'm talking about that updated information. Here is the U.S. Department of Justice. You have the right to work. Don't let anyone take it away. And actually, I blew it out from this little pamphlet that they have. Back in this time, this is for your I-9 form when you first got hired. These are documents that you can use to prove both your identity and work authorization. There's a lot of stuff. I'm not going to read it all. Just the first one, which is the most important one for us, is that U.S. passport you can use, expired or unexpired. Well, that changed in April 3rd, 2009, where you can now only use an unexpired passport, because they said because of fraud and tampering. Now, I always found it kind of odd or weird why they allowed you to be able to use an expired passport at that time anyway, because that was the first thing I thought. Well, what if somebody tampers with it? It's expired, so they don't care if they, whatever. So, anyway, that's changed. In the Uniform Commercial Code, as many of you know, I've talked about a lot, U.C.C. 1-207 has been revised to U.C.C. 1-308. I don't know why, and that was done in 2004. I don't know why they did it. I can only speculate that people have started figuring out the U.C.C. code and applying it to their lives, dealing with moving violations, parking tickets, loans, and etc. Writing that statement there, and therefore exercising the remedy and recourse and discharging that debt. And I'll explain all of that to you in that chapter. But what I found out about this, weird about this, is that 207 is still in effect. It's just been revised. It hasn't been taken out of the code books, or it's not invalid still. You can still use it. They just revised it to 308. I don't get it. Maybe they just wanted to see if people would catch on or something. I have no idea, but I just find it kind of weird, because it's still good. You can still use it. But, just 2 examples of stuff that, to be aware of that had been changed or updated. The next thing to say to you is this. I understand that a lot of this information I'm going to be sharing with you may be very scary for some, and I understand that. And a lot of you out there, I'm sure, have families and careers and good jobs, and you feel that this information may jeopardize that. You can't talk about it. I have my feelings on that, but that's up to you. I'm just sharing the information with you. What you do with it and so forth is up to you, but at least you're aware of it. I know that this information, I've suffered greatly from it. I've had, issues with jobs, where I've been fired and blackballed because I refused to pay the tax or use the Social Security number, which is my right. I'm all within the legal guidelines of that. And I just want a lot of these people to steal my money. And, I have battles over it. Epic battles. And it's, I don't say a lonely life, but, it's tough. It's tough. And I understand that for a lot of people, they're not willing to do that. I am. I don't have the obligations that most of you or many of you have. I don't have a wife, children, family. I don't have a high-end or good job in that sense. And, this is maybe part of the reason. Maybe I'm, here to be the one to, I won't say be sacrificed, but, to help or to get this information out there. So it is what it is. I'm just sharing that with you because I think that's very important for me to state. I also want to thank all of my now over 300 followers or subscribers on YouTube. Thank you very much. I really appreciate it. And I know some of you say 300, I got 5,000, I got 50 million. I know, but for me that's a lot, and I appreciate those people because, as I always tell you guys, I'm doing this out of the sincerity of my heart. I have no hidden agenda. I'm not being paid. I'm not a part of any groups or organizations. Not saying that's a bad thing, just saying that I'm basically a one-man unit and do the best that I can with providing you the truth and the facts best as I know it. So like I said, I really appreciate that from you. I guess that's about it. So, like I said, I'm breaking this down into the parts so that you can, watch one part one day if you want, and another part another day. And I'm just breaking it down that way because it's going to be long, lengthy, reading, and you got to pay close attention because a lot of what I'm saying is very, very important that you hear and understand what you are hearing. So, with that in mind, I want to go ahead and jump right into it. I don't want to waste any more time. I don't want to say waste, but I don't want to spend any more time on this. And chapter 1, or part 1, is going to be entitled Word Definitions and Meanings. So let's go ahead and jump right into it. And stay tuned, and I'll see you. Okay, welcome to part 1, word definitions and meanings. Now, you read that about your unalienable rights. It's imperative that you understand that your unalienable rights or unalienable rights are the highest form of rights that you can have. They were given to you by your Creator, endowed to you. You cannot give them away. They cannot be taken away from you. They are your rights. And that's the highest form that it comes in. And that was stated in the Declaration of Independence in 1776. Now, here's where the controversy, or I don't want to say, but conspiracy comes in. They say unalienable and inalienable rights are one and the same. But the argument is that they are not. And here's what is said about that. Inalienable rights. Rights which are not capable of being surrendered or transferred without the consent of the one possessing such rights. Morrison versus State. You can surrender, sell, or transfer inalienable rights if you consent either actually or constructively. Inalienable rights are not inherent in man and can be alienated by government. Persons have inalienable rights. Most state constitutions recognize only inalienable rights. So they're saying that you can give that up as an inalienable right, but not as an unalienable right. So there you go with the trickery of the terminology. You got to know the difference. Now let me point out to you and explain to you about the trickery of words. These people are masters of it. Let me give you a real example. Now, there was a book that I had entitled America's Secret Destiny. The book was stolen at a very high-profile celebrity's home in which I worked one day, and I'm not happy about it because the book has not been returned to me and it was clearly stolen. The whys and the whos, who knows? But at any rate, in that book deals with a lot of this type of things or types of things. What it was stating in there, and I was reading it really for the first time, was explaining how Ben Franklin was talking or explaining how, or it was explaining how the trickery was of tricking people with words and things. Let me give you the example. I don't remember it exactly, but it goes something like this. In this, Ben Franklin during the time, whatever it was, 1780 something, was asking for something like, I'm not sure, the government or whatever, or people to help with paying for something. And he was saying, we need this amount of grains in order to help the people to continue with what we're doing. Well, he was saying grains. And people were assuming or thinking that he was talking about as in grains of food. But he was talking about grains of gunpowder. And he was tricking the people by making them think one thing when he was actually meaning another thing. The other example in that same scenario was the people asking the people that we need this amount of fire wagons, I believe was the term. What was he talking about? He was actually talking about that we need the fire wagons to help, in the event that we need to take care of something, whatever. He was talking about cannons. He was referring to the cannons as fire wagons because it's very similar. But they were talking about fire wagons or engines, or at that time they didn't have engines, but when a fire, and when they had the equipment that they used in those days to put out fires. See the trickery? So that's the way they've been doing this for over 200 years, with tricking us with the words of using. And I hope you get that. The next big thing to tell all of you out there, stop fighting for civil rights. Civil rights are a joke. Why? I'm going to tell you why. You know what a civil right is. You want your unalienable rights. Always. Never your civil rights. Why? A civil right is a right given and protected by law. And a person's enjoyment thereof is regulated entirely by law that creates it. Nickel versus Rosenfield, 1927 case. What does that mean? Civil right was given to you by government. It could be taken away by the same government. What are unalienable rights? God-endowed rights that the Creator gave you. That cannot be taken away from you. You gotta learn these differences and definitions, because this is how they're tricking you, or us. Because I'm part of this too, but I've been studying this stuff for quite a while, and I have a little grasp of a lot of it. The next big area that you have to understand and get is stop calling yourself a person. You are not. In law, there are different words that mean different things at different times. Yes can mean no, no can mean yes. In everyday lingual, yeah, hey man, I'm gonna go drive here, and hey, I'm a person too, whatever. But when you get into court, or you start dealing with governmental issues or things, you cannot use these terminologies. They will incriminate you. Now there are people who say, oh, it's the same, it's one and the same, and it's just, that's that argument. But looking at the evidence in the laws and in the codes and in the all the different legal writings and so forth, and papers and quotes and journals, so forth, they listed out here what it means. Now check this out. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings. United States of America versus William M. Slater, that was a 1982 case, I believe, in Delaware. See what I'm saying? Individual also ties into this person. The Constitution said, we the people, not we all the persons. There's terminology differences here, folks. And you got to get it. Because this is what they're doing and using to trick us. So you have to understand or remember the slave master mentality, the master and the slave mentality. They don't want you to know these definitions. Trust me. And this will all start to make sense as we go into the next chapter, because this all ties in with this whole state citizenship stuff, with U.S. citizenship, a federal, a sovereign state, free citizen versus a United States slave, federal corporation citizen. You know, the difference there. And we'll get into all that later. I mean, there's a lot of stuff to cover here. But I just want to give you some of these basic terminologies and understanding the different uses of words. Let's see here. I already hit that. Another thing is your birth certificate. Your birth certificate, federal birth certificate, is another trap. It was what they were using for black slaves during the time of slavery as property. And in today's use, it's for collateral or payment on the federal national fictitious debt. And what they do, it has a serial number on this, and I covered this in my documentary, The Federal Reserve 100th Anniversary, that they use that to enslave you and to make you obligated to the national debt. And the whole capitalization of your name, and let me state that right now, and I also covered that, called the straw man, or the actual terminology is strenumus homo, a man of straw, one of no substance put forward as bail or surety, blacks first. Straw man, person. Oh, there's that word, person. Affront, a third party who is put up in the name only, put up in name only to take part in a transaction in name only. Nominal party to a transaction. Black six. The term is also used in commercial and property contexts when a transfer is made to a third party. The straw man person, simply for the proposed purpose, of retransferring to transferor in order to accomplish some other purpose not otherwise permitted. Note, or C note, strenumus homo dummy corporation so. See what I'm saying? It goes on, but I'm just giving you a general understanding of it. So when they put your name in all caps, look at your birth certificate, look at your driver's license, look at your credit cards, your bank statements, social security number. That's the way they do it, in all caps. Your vehicle registration. That's not you. That's not the live human being. That's the dummy, the straw man. And you must understand this in order to free yourselves, or to at least have the knowledge to know what's happening to you. It's very, very interesting stuff. The next thing, do you have a marriage license? Do you like three-party marriages? Well, what is a marriage license? This is what is stated about that. The state is a party to every marriage contract of its own residence. There's that term, residence, and you'll hear about that in a moment. As well as the guardians of their morals. Roberts versus Roberts 1947 case. Wow. So the government gets involved in your marriage. That's why you have the CPS on you. And technically, from what I understand, the government can come in and tell you guys, hey, you got to paint your house red, not blue, because you agreed to have a third-party marriage and your morals, and they set what you can and can't do. That's why certain getting into the sexual acts are illegal in certain states. You can't, I'm not get into that, but what you can and cannot do with your wife or husband. It gets crazy. Ties in, read it. It all fits in, it all makes sense, and it'll make more sense later. But that's what that is. So, now, another thing is that in court, you know, people say I have a right to trial by jury. That's only been recently. That started in 1968. I thought we always had a right to trial by jury. Yeah, if you were a sovereign state citizen, you did, but not as a U.S. citizen, and we'll cover all that. But just interesting things that I'm passing up here in seeing. And it says here, Declaration of Rights. As far as federal due process is concerned, the right to trial by jury in state trials only dates from May 20th, 1968. The date of decisions of Duncan versus Louisiana, Bloom versus Illinois, and Dyke versus Taylor. All of this is just evidence and showing you, you know, this is the stuff I'm making up or someone made up. These were in the law books and different code books that these various groups or this particular group went around and collected over the years, because some of these people like researching and they spend, you know, that's what their hobbies are, is going around finding old law books from the 1800s, the early 1900s, etc. Are you registered to vote? Did you know that when you register to vote, it is permanent until you cancel it? Did you also know that you have a lien on all your property when you register to vote? The registration of a voter is permanent for all purposes during his life, unless and until the affidavit of registration is canceled by the county clerk for any of the causes specified in this article. Now, it gets into some stuff here, because as a sovereign state citizen, you're not really allowed to vote, because it's not the sovereign government you're voting for, but the corrupt regime of the foreign corporation federal government. Now, there's people that say, I don't like it, because then I want to be able to vote in the process, but under the system, as a state citizen, you can't. You just can't. So, and I don't know of any update on that, like if that's changed over the years or what. I don't know. I haven't followed up on that. The next thing I want to get into is your motor vehicle. Wow. Here we go. Let me hit you this real quick so you can understand and grasp this. Words to understand. Never ever use the word motor vehicle, passengers, driving, resident, or reside. I will start first with the resident, reside. I am a resident of the state of no, not as a sovereign state citizen. That's a word term for a federal foreign U.S. government, the slave government. You are to use the term abode, live, take up house, domicile. Now, in driving, I don't drive. I travel. I journey. I do locomotion. That's what you say. You don't say I have passengers. Hey, I've got 2 passengers. No, I have guests, my friends, my family. Motor vehicle. I use a conveyance. My car. I'm not sure about automobile. I don't know if that's applicable. I'm not sure. Piece of machinery. You never say a motor vehicle. Those are terms deemed for U.S. citizens. Now, I've seen it and been in court where the judge has said, well, you understand that driving is a privilege. And the person's like, I understand that, Your Honor. Yes, sir. He doesn't understand. Because that judge didn't tell you the whole story. He said driving is a privilege. He only told you half of it. It is true, but only half true. Why? Because if you're a sovereign state citizen, driving doesn't apply to you. Traveling is your right, and it can't be infringed upon. They don't tell you that. And the whole thing here I'm trying to tell you is that when you walk into any governmental agency, and especially court, those people automatically assume that they have jurisdiction over you and I. Unless you stand up and give them or set them straight the fact that you are not under their jurisdiction. Now this argument, like I said, with the whole, some people are saying that you are both a U.S. citizen and a sovereign state citizen at the same time and this and that. I disagree. I've seen the debate and I felt I've made my decision that that is absolute. And we'll get into all that. I keep saying that, but the next chapter gets much deeper. But I just have to give you a basic knowledge or information about word terminologies. Because that's how you're getting tricked into this. And you'll see how it all ties together. But those are things that you say. And what is the definition of motor vehicle? Well, let me say this to you. Let me first just read this little bit to you because it's kind of interesting. This is a summary of a case back in 1914 called Hendricks versus Maryland. Now, Mr. Hendricks was a resident, here we go, it means a U.S. citizen, of the District of Columbia. Everyone understands that the District of Columbia of Washington, D.C., it is not one of the sovereign states, but the United States, and like I said, we'll talk about that. He was a resident of the District of Columbia. He drove his car into Maryland. Maryland had a law that licensed all commercial vehicles, and the citizens of Maryland were exempt from such regulation. Mr. Hendricks was cited and convicted, and he appealed to the U.S. Supreme Court. There, the court ruled that a resident, a U.S. citizen, when they leave the District of Columbia, were involved in interstate commerce. Therefore, they could be regulated and licensed. This regulation did not infringe on the common law right to travel, as they, U.S. citizens, do not have the common law right to travel. Now, the writing on this, what I'm going to read to you, is a little bit, I won't say hard for me to read because it's really kind of small and what have you, but this is, I'm not sure this was taken out of a legal book or matters of application or historic. But anyway, in the matter of the applications of Charles Stewart for a writ of habeas corpus. Check this out. Here it says, in classification of drivers of motor vehicles, whether reasonable. The Motor Vehicle Act, Stats 1913, page 639, is not unconstitutional as making an arbitrary and unwarranted classification, in that it requires professional chauffeurs or drivers of motor vehicles for hire to pay an annual license tax, but exempts all other operators of such vehicles from such tax and regulation. See how they broke that up? They're talking about the latter part replies or refers to citizens, sovereign state citizens. So, what's the definition of a motor vehicle? This is what they say. Motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways, in the transportation of passengers or passengers and property. What does that mean? When you drive from point A to B, work to home, the government is looking at you as property, or let's say a package being delivered on the interstate, involved in interstate commerce, official use. That's the way they're looking at it, as a U.S. citizen with their driver's license. Now, years ago in California, on your vehicle sticker that you stick on the back of your car every year when you register your car, it used to have, it was very faint, but I remember it, and I wish I had kept one, but you could see, if you go back to like 94, 5, if somebody has a license plate from them, and they have that sticker on there, you should be able to see it if you look closely. But very faint in the background, it said official use, or official use only, something like that. Or now when you see cars that are government cars on the street, they don't have stickers on them. It says the plate on there, official use only, or official use. Why? What does that mean? The government owns it. That's their car. That's what you were putting on there when you stuck that on there, that this is a government-owned car. Trickery. See what I'm talking about? I hope you're beginning to understand and see all of this and how this all is starting to make sense. Now, there's so much more about all of this, and I'm just skimming over to hit some of these important, terminologies for you, so that you understand what I'm trying to tell you. Because there's a lot here, believe me. There's just something else I kind of wanted to read to you, and we're going to run into it again anyway, but bear with me. Right here. I forget what the CJS stands for, but I forget. California Justice Systems or whatever. But this is what states in here. It's very interesting. And let me say this to you. Can any corporation have its own citizens? No. They can only have franchises of the corporation. Have you ever heard of the Franchise Tax Board? I certainly have. You guys out there know that. And for those of you that know my battles with them, you might find that a little bit funny, but not really. But did you know that the United States government is a foreign corporation as it relates to the state common law? Here it goes. In this journal, it says the United States government is a foreign corporation with respects to a state. 13. And it goes into the cases and so forth. I just thought that was pretty interesting. We'll cover all that later. The other area too to talk to you about and I'm not going to get deep into it, but your property, when you own your home, you think, or land, you think you own it. You don't. And this is what they're saying that the American Revolution was about, was property rights. And they're saying that the prime reason for changing your status from a citizen and member of the sovereignty to that of a U.S. citizen who is of subject status and does not have the right of property, only the right of possession and ownership. It requires all three to have land in the lodium. You must have your land and own it in the lodium. What is that? Most of you've never heard of it. You're real estate agents and people who are claiming you're real estate masters and this and that. How many of you know this? What does allodio mean? Free, no holding of any lord or superior, owned without obligation, or I can't read this word, vassalage, or fealty. I don't know what that means, but the opposite of feudal. Barker versus Dayton. Allodium, land held absolutely in one's own right and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. It's deep. I'll let you marinate on that. Remember, land is not property. All the land in the 13 colonies was given to people in allodium. When you have land in allodium, you do not have to pay property tax. You cannot take a mortgage out on it. It can never be taken away from you, as it is yours and your posterity's. This is what this is all about. Taking everything from us, breaking us. And we have fallen for it. We've been so indoctrinated with lies, miseducation, that we've fallen for this. Alright, we spent enough time on this and I want to move on and get into some other stuff. But before I do that, I want to kind of read to you something that's kind of funny, but this is an actual real thing that occurred. Let me read this to you. This was a standard screening questions. These questions were administered by Mr. Alberto Gutierrez, Deputy Administrator, Arizona Department of Transportation, at approximately 2:00 p.m. on August 24, 1989, after confirming that Mr. Cooper had met with Mr. Carl Davis, the Governor's Special Assistant over state agencies. Mr. Goodyear, before we go any further, I need to ask you our standard screening questions. Question number 1, Mr. Goodyear. Are you a citizen of the United States? Mr. Cooper's answer, no, I am not. Question number 2, Mr. Goodyear says, are you a resident of Arizona? Mr. Cooper's answer, no, I'm not. I was born in Phoenix. I have lived in Maricopa County all my life, but I am not a resident. I do not reside. Mr. Goodyear, question number 3. Are you registered to vote? Mr. Cooper's answer, no, I am not. Question number 4, Mr. Goodyear, do you have a driver's license? Mr. Cooper's answer, no, I do not. Question number 5, Mr. Goodyear, do you have any motor vehicles registered in Arizona? Mr. Cooper's answer, no, I do not. Question number 6, Mr. Goodyear, are you employed? Mr. Cooper's answer, no, I am not. I am not employed. I am not unemployed. I am not self-employed. I am not gainfully employed. In fact, I am not employable. But I work. Besides, Arizona is a right to work state. Mr. Goodyear nodded his head in agreement and went on. Question number 7, Mr. Goodyear. Do you pay state and federal resident income taxes? Mr. Cooper's answer, no, I do not. Question number 8, Mr. Goodyear. Do you pay property taxes in Arizona? Mr. Cooper's answer, no, I do not. Mr. Goodyear, do you have a marriage license? Mr. Cooper's answer, no, I do not. Question number 10, Mr. Goodyear, do you have children enrolled in public school? Mr. Cooper's answer, no, I do not. My children are home taught. Mr. Goodyear then said, you've really done your homework. I like that. So, you see what I'm saying? The terminologies are very important, and I forgot to mention one last part, and we'll get into all this later once again, but it's important. The employee-employer relationship. The legal definition of employee is working for the government. The legal definition of employer is government or government-protected workplace. The W-4 form is a Class 5 gift tax form. By signing this, I am stating that I am receiving the gift of employment from the government. So everything I receive is profit or gain as a U.S. citizen. So right there, I hope that you all out there are getting this and understanding this. And the whole purpose and point of all of this is this. You've got to reclaim your sovereign, free being, human being, self. Not person. Not falling under the U.S. Slave of being a person. And like I said, we'll get into the whole state citizen in the next part, but basically, it works like this. You want to use whatever terminology you can to describe yourself as being that free sovereign being. Not having an allegiance or being owned by anyone. I'm saying God, man, beast, whatever. But as a sovereign comes responsibility for your own life and actions. Because every day I see people who are acting like fools and not being responsible for themselves. Blaming others and blaming this and that. Yes, these people are out there and they are hindering our life and so forth, but that doesn't give you the excuse to say, oh, well, this, and, you know, it doesn't matter or whatever. Be responsible for yourself. Okay? And this whole thing, it's all about freedom. So if somebody's telling you, well, that's not true, and what's the difference, and who cares, or whatever, ask them. So do you want to be a slave, or do you want to be free? What is it? What is it that the government's trying to say to me? I'm telling you that I'm this free, sovereign human being. That as long, and this is what we say about being a sovereign citizen, that you are responsible for your own life and actions. As long as you do not infringe on the rights of others or damage their property, or, in this term, person, you don't inflict bodily harm on that person or that being. We could say that, I guess. And keep all agreements entered into knowingly, willingly, and voluntarily. As long as you're doing that, you are operating in the free spirit of sovereignty of your human self. So, with that in mind, stay tuned for part 2, state citizenship versus U.S. citizenship. Okay guys, back for part 2, state citizenship versus U.S. citizenship. Now, I'm going to read to you what is a sovereign citizen. And this is an updated version because the way it was, the way the laws were written and everything, that state citizenship was based on, they used to call it white state citizens. Now, when I read different things to you, it's going to still mention that and talk about that. But this is the more updated version because remember, at that time, America was racist, or more racist, or basically white people who were fully in control at that time. And that was who was here. Because it certainly didn't apply to black people, it certainly didn't apply to Hispanics or Mexicans, it certainly didn't apply to Indians. So it was white people who were considered the free white sovereign state citizens. But those have all been amended and changed to now include everyone. So when you hear me saying that and talking about the white state citizen, understand that was, because many people out there, you're smart, and you know, people say to me, well, you know, that was based on white supremacy and the white thing. Yeah, it was. But the fact of the matter is that it's been changed to include us all now who are American, born citizens, native-born Americans. So, understand that, and I get that, and I know that white supremacists use a lot of this or whatever. But when George Washington or the forefathers came here, they were just trying to free themselves from the slavery bonds of Europe, of King George, etc. So it's the same thing. So don't let that bother you. And there are things that I don't agree with also within the parameters of the common law, and that gets into like the abortion issue, homosexual issue, and so forth. And I believe they were against interracial marriage and all this other stuff that's just ridiculous to me. So there are aspects and elements of everything that I don't like or that I do like, and vice versa. So I'm just reading to you what the law and what the issue is that most of you have never heard about. Because I guarantee you most of you have never heard the expression, I'm a state citizen and whatever. Maybe more so now than back years ago when I talked about this stuff and people looked at me like I was some crazy, nutty alien. But as the years go by or went by, I would get phone calls every now and then. Hey Kevin, you remember me? I used to work with you, blah, blah, blah. And I used to talk about that stuff and I used to laugh at you. Well, now I live in Florida and I've run into a big group of people. I moved to Texas, and that's what happened. So anyway, let's get going because there's a lot of dry reading, and bear with me on this. And I want to read this to you because, like I said, I just want you to understand that it's been updated because I'm going to be reading some stuff from the original kind of state citizenship stuff that's going to mention the whole white thing and so forth. And I just want to make it clear and explain to you what that meant. What is a sovereign citizen? A sovereign is a state citizen of the California Republic or a state citizen of another one of the 50 common law states of the Union. A sovereign is not a federal citizen or U.S. citizen. However, because of state citizenship, a sovereign is a citizen of the United States of America. There is a legal difference between the two. A sovereign has revoked power of attorney from any government agency they may have unknowingly contracted with in their lifetime. A sovereign is a citizen that has revoked and surrendered their Social Security number. They have also sworn an oath to protect and defend the people and the Constitution of the California Republic, 1849, or their own common law state against all enemies, foreign and domestic. A sovereign is a sui juris, which is defined in Black's Law Dictionary as of his own right, possessing full social and civil rights, not under any legal disability or the power of another or guardianship, having the capacity to manage one's own affairs, not under legal disability to act for oneself. Now that term civil rights in there may not mean the exact same that we talked about earlier with civil rights. There's some of the wordings that I guess sound the same or mention the same, but we're not talking about the same civil rights that Congress has granted to the U.S. citizens. So don't let that throw you off. A sovereign adheres to the common law. What it really means, excuse me, is as long as one is responsible for their own actions and maintain the sui juris status, one can do whatever one pleases as long as two conditions are met. And I already read this to you, but I'll redo it or reread it again. Do not infringe on the rights of others or damage their property or person, and keep all agreements entered into knowingly, willingly, and voluntarily. And once again, that thing, persons, don't let that throw you off. In this meaning, it's talking about you. I mean, could have been worded better, maybe, but anyway, that's just an overview of that. The other thing I want to say to you is that there's great debate about the whole state citizen, U.S. citizenship thing. There are groups of people out there who work hard and diligently trying to decipher the codes and laws and explaining the original meanings and intents of it. Now, I've been a part of some of these groups over the years, and I want to make sure you understand that you have to make up your own mind and research and look at it. And like I said, I'm not the master of this stuff. I don't, to be honest with you, I hate it, because I hate having to look into law and learning all this stuff. But I've learned that through necessity, I must learn this stuff, because we're being enslaved every day. And if you don't know your rights, well, you're going to be trumped on. And that's what's happening in this country. And I hate it. So through that necessity, I'm learning and have learned a lot of this stuff. Like I said, I'm not a master of it, but I feel I have a good grasp of it. But anyway, so there are two groups of people. Richard McDonald is the head of the California State Citizen Movement. And there's a gentleman by the name of Payman Montejade. He's the founder and president of the Freedom Law School that teaches this stuff, but he's against the state citizenship, saying that he used to believe in it and think it was real until he started reading and researching the cases more, and feels that it's not what it means. It means you are both the same at one time, and Richard says no. And you know, I've been to the debates between those two guys many years ago, and I have to make my personal feeling is I think Richard is right with the state citizen, because the evidence is here. It's showing you that, and I'll get into that, it's showing you that there's something different was created with the 14th Amendment. And that's what this whole thing really is, when it got heated, was when the 14th Amendment got added to the Bill of Rights. And we'll get into all of that, and I'll explain that to you, and hopefully it'll make sense to you. But with Richard and Payman, it's like Malcolm X and King. They were both trying to accomplish the same thing. They were just doing it in a different way. And it's the same thing with these guys, you know. So I love them both for what they do, and and try to help us, and help us with this information. So all right, this can be a little bit of dry reading here, but you got to understand this, and you got to hear it out. I'm going to try to cut as much as I can, you know, of it, so that it's not too boring and dry. But here we go. Which citizen are you? This was done in November 1989. I believe this was on the TV show Dateline America. What kind of citizen are you? Are you a 14th Amendment federal citizen, or are you a citizen of the several states as described in the Constitution as it was originally intended by the Founding Fathers? Are you aware there exist in this nation two separate and distinct classes of citizenship? To begin with, I must define what the definition that the original Constitution used when it referred to the citizens. The phrase citizen of the United States has a specific meaning in the original Constitution for the United States of America, 1787. The definition and intent of the Constitution was that it described a free-born citizen of the several states. The 14th Amendment added a second distinct meaning to this phrase. So now the phrase citizen of the United States has two separate and distinct meanings which are not compatible with each other, and indeed in the later issue will be shown to be at odds with one another. They are, number one, a free-born white state citizen in the several states is an individual whose inalienable rights are recognized, secured, and protected by the various state constitutions. against state actions and against federal intrusion by the Constitution for the United States of America in 1787. Now here we go with the word individual and inalienable rights. It's being used there in the sovereign sense. Like I said, you got to know the difference. Inalienable rights, you know, there's that debate. We already went over that. I'm not going to go over that right now or again. And the individual is kind of tied in with the person. But like I said, there are words that you have to use it to mean not the federal meaning at certain times. And I believe that he's using that in that sense right here. So anyway, go back. The 14th Amendment federal citizen who is a second-class citizen, a juristic person, a citizen of foreign or interstate commerce, one who has congressionally granted privileges that are almost equal to the white citizen. I say almost because these privileges are secured against a debt of submission to the morality legislated by Congress, including income tax. These individuals are subject of Congress, alien juris, under their protection as a resident of a state, a person enfranchised to the federal government, the incorporated United States, defined in Article 1, Section 8, Clause 17. The individual states may not deny to these persons any federal privileges or immunities that Congress has granted to them. This specific class of citizens is a federal citizen under Amity international law. As such, they do not have unalienable common rights recognized, secured, and protected in the constitutions of the states or of the United States of America 1787, such as allodial rights to property, the right to inherit, the unalienable rights to work and contract, the right to travel, life, liberty, and happiness, among many others. Thus, the federal citizen is a taxable entity such as any other corporation and is subject to pay an excise tax for the privileges that Congress has granted them. The white de jure citizen is a state citizen by birth and race to common law, first. Then, as a consequence of his state citizenship, he is a citizen of the United States of America, second. He owes his allegiance to his state of domicile first, and then to the union of the several states. The 14th Amendment citizen is a de facto citizen, a citizen of the United States, spelled with a small c, and we'll get into that. Corporate citizen of the District of Columbia is territories and federal enclaves per Article 1, Section 8, Clause 17. First, as a consequence of this citizenship, he is allowed to be a resident within the several states. For this and other privileges, he owes his allegiance to the United States Corporation per Article 1, Section 8, Clause 17. First, then to the state of his residence. Note that domicile and residence are not synonymous. See Black's Law Dictionary, 5th edition. The Internal Revenue Code's definition of the term citizen is identical to the wording of the 14th Amendment and can only apply to the subjects of Congress. The Social Security number, a badge of slavery, is the main registration number of the de facto 14th Amendment citizen. So Congress can tax their subjects, slaves, wherever they are resident. Now, which citizen are you? A white state citizen or a de facto resident? You must decide. This is a personal decision, and notify the appropriate government officials of your status with respect to them. Be prepared though, the United States District of Columbia does not want their slaves to escape. If they did, the profit of the Federal Reserve would dry up and you might lead the exodus out of Egypt. See? Very informative right there. So you got to understand this. The next part I'm going to read to you, I'm going to cut a little bit because I don't want to make it too long and dry. It's called Legal Words and Consequences. Excuse me. First, you must understand that this is an educational form, and I will give you the meanings that are utilized by the various governmental agencies to deprive you of your rights and property. The word person, as it is used in most of the statutes, refers to the same person as defined in the so-called 14th Amendment. It does not include everyone, as you are led to believe. There are several court cases that define who is that specific person, and one of those cases is von Valkenburg versus Brown, 43 CAL 43. Next, the term United States has three different distinct and separate jurisdictional meanings. This has been stated in Hooven and Allison Company versus Evatt, 324 United States 652. There the court stated, the term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. It may designate the territory over which the sovereignty over which the sovereignty of the United States extends, or it may be the collective name of the states which are united by and under the Constitution. Each of these definitions have completely different jurisdictions and cannot be mixed. Do you know which of the meanings are being utilized when they say United States? When in doubt, ask. This always brings some type of answer, and you will at least know for yourself what they are doing to you with your permission. Very crucial. And forgive me, all the reading and doing this stuff is making me a little hoarse or what have you, so and mispronunciation of certain words that I really don't know a lot about. So, all right. This is a little longer part, but it really, in my opinion, sets it all off, and it's very detailed as explaining to you a little more in depth. So let's do this. Is the United States government guilty of genocide? When this nation was formed, when this nation was formed, I guess, also, each of the individual states of this union had their own citizens with a capital C, as defined in the Constitution, but then came the so-called 14th Amendment. For clarification purposes, the term citizen, when used in the constitutional sense with a capital C, shall designate a state citizen, as per the intent of the founding fathers of this nation. When used with a small c, as it is used in the so-called 14th Amendment, shall designate the federal citizen, which is a different class of citizen. In law, every letter in a word is important. The capitalization of a specific word means a specific thing. The use of the same word without the capitalization may mean something else. In this case, it does. The citizen does not include the citizen. The large C or capital C does not include the lowercase c. The word resident, capital R, does not include the lowercase r for resident. D. There is a clear distinction between national and state citizenship. U.S. citizenship does not entitle citizens of the privileges and the immunities of the citizen of the state. K. Tashihiro versus Jordan, and it's a lot of other legal cases that go into that. I don't want to read it all. Black's Law Dictionary, 5th edition, agrees with the distinction between different classes of citizenship. Privileges and Immunities Clause. There are two privileges and immunities clauses in the federal Constitution and amendments. The first being found in Article 4 and the second in the 14th Amendment. Section 1, Sentence Clause 1, the provision in Article 4 states that the citizen of each state shall be entitled to all privileges and immunities of citizens in the several states, while the 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Pages 1078 through 1079. Note the lack of capitalization in the wording used in the 14th Amendment. This specifically means that the word citizens, small c, privileges, immunities are not the same as in Article 4. The state of California was admitted to the Union of the United States in 1849 by an Act for Admission of California into the Union, Volume 9, Statutes at Large, page 452, and was admitted into the Union on equal footing with the original states in all respects whatsoever. The state of California was required to have its own citizens who were first state citizens, then as a consequence of state citizenship were American citizens, known as citizens of the United States with the capital C. There were no specific class as this, but traveling and protection by the United States government while out of the country. They were generally called citizens of the United States with a capital C. The Constitution for the United States of America, 1787, used the term citizen of the United States in Article 1, Section 2, capital C, and numerous other sections, each time with capitalizations. This referred to the sovereign political body of state citizens. This citizen is entitled to all the privileges and immunities of the citizens of the several states under Article 4. Congress utilized the same term, citizen of the United States, qualifying it with a small c, to distinguish the federal citizen. In the so-called 14th Amendment, these citizens have only statutory rights granted by Congress. Thus, Congress and most of the judiciary have acknowledged that an amendatory act cannot alter the original intent of the Constitution. Therefore, Congress did not alter the meaning of the term citizen of the United States, capital C. It still remains the same, a citizen of a state. In the past, the judiciary, without the distinction being properly brought forth, have made rulings based upon the federal citizens who are residents in a state, not state citizens domiciled within their own state. The statement by Chief Justice Taney in Dred Scott versus Stanford 19 HOW 393422 in defining the term persons. The judge stated, persons who are not recognized as citizens. See also American and Ocean Insurance Company versus Cantor 1 PET 511, which also distinguishes persons and citizens, large C, capital C. These were the persons that were the object of the 14th Amendment to give to this class of native-born persons who were residents in the Union of the United States citizenship and authority to place other than the white race within the specific category of citizen of the United States. To overcome the statement in Dred Scott Supra that only white people were citizens and all other persons were only residents without citizenship of the states, Congress then passed the Civil Rights Act of 1866, 14 Stat 27, the act of Congress called the Civil Rights Act, 14 U.S. Stats at Large, page 27, which was the forerunner of the 14th Amendment, amply shows the intent of Congress. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color shall have the same right in every state and territory of the United States to full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens. Again, note the lack of capitalization. This was the intent of Congress, not to infringe upon the Constitution or the status of the de jure citizen of the several states. The term person did not include the white de jure state citizen. It was never the intent of the 14th Amendment to subvert the state's authority or that of the Constitution as it relates to the status of the de jure state citizen. People versus Washington 36C, 1869, overruled on other grounds. French versus Barber 181 U.S. And it goes on. The so-called 14th Amendment uses language very similar to the Civil Rights Act of 1866, and Harlan J. in a dissenting opinion quoted from the veto message of President Johnson his interpretation of its meaning. It comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks, persons of color, Negroes, mulattoes, and persons of African blood. Every individual of those races born in the United States is made citizen thereof. Elk versus Wilkins 112 U.S. 94 114, so on, so on. It was the intent of the so-called amendment that the de jure citizen in the several states were not included in the terminology, as they were by birthright citizens as defined in the preamble and could receive nothing from this so-called amendment. No white person born within the limits of the United States and subject to their jurisdiction owes his status of citizenship to the recent amendments to the federal Constitution. Van Valkenburg versus Brown, 43 California Sub 40 CT 43. This last part is where it gets deep, and I want you to fully, it's all deep, but understand this. This is the last of it. And this is how it all ties in. In 1913 came the Federal Reserve Act, our downfall. Then in 1924, Cook versus Tate, which stated that citizens of the United States, wherever they are resident, are subject to the income tax, which is based upon citizenship of the United States, spelled with the small c. Now, the government cannot tax only the citizens of the United States under the so-called 14th Amendment and not tax the white state citizens. If they did that, there would have been a revolution here in America. So the Federal Reserve banks deliberately caused a crash of 1929 congressional record and made all the people who had saved for their old age lose their money that they were saving. Then the government in 1935 instituted Social Security, and this was controlled and handled by each state on a state level. So the state could handle their own citizens, capital C, the sovereigns, and residents under the so-called 14th Amendment. Then in 1939, the U.S. government repealed the Social Security Act, which is a little known fact, and reenacted it into the 1939 Income Tax Code with a new intent and meaning, classifying everyone who has a Social Security number a taxpayer and a federal citizen of the United States under the so-called 14th Amendment. Now, the U.S. government, knowing this, under prompting of the Federal Reserve, stated that the people of America were saving too much money, congressional record, and therefore should pay an excise tax, congressional record. This was the victory tax to help out World War II. But in 1 year, the government made so much money on this tax, they decided to repeal the 2-year limitation on this victory tax and telling no one. They made it a permanent tax on the citizens of the United States who have a Social Security number. There you go. Webster's Third International Dictionary, page 947, defines genocide as this: the use of deliberate, systematic measures as killing, bodily or mental injury, unlivable conditions, calculated to bring about the extermination of a racial, political, or cultural group. 2. Or destroy the language, religion, or culture of a group. The writer believes that the United States government is guilty of using the so-called 14th Amendment and Social Security to force unlivable conditions. You cannot work if you don't have a Social Security number, to accomplish genocide, as it is described above, to enlarge and maintain a revenue base for the profit of the Federal Reserve. Forced integration is destroying the white political cultural group known as state citizens in all the states. Now, anyone can do their own research and arrive at the same legally correct determination that I have. I did not cite all the congressional records, but you could look them up if you were so inclined. The proof is there, so what are you going to do about it? Continue to be a victim of genocide? That's some deep reading right there. So, kind of enough said on that. It's a lot to digest and so forth, but that's what we're trying to teach and tell you as Americans. What's going on? How we're being tricked into paying taxes and having Social Security numbers and driver's license and birth certificates, etc. So right now, I just want to go over some of the highlights of just different things that talk about the separation of state citizens and federal citizens, and that have been collected through the years in law books and journals and codes and so forth. I mentioned to you the whole Van Valkenburg versus Brown case. Now, this case is an 1872 case that shows the true intent of the so-called 14th Amendment. Because what people don't understand is, and I'll get into it, but I'll read this little part to you first. Purpose of the 14th Amendment. The purpose of the 14th Amendment to the Constitution of the United States was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States, who could not be brought within the operation of the naturalization laws because native born, and whose birth, though native, had at the same time left them without the status of citizenship. Such persons were not white persons, but in the main were of African blood, who had been held in slavery in this country, or having themselves never been held in slavery, were the native-born descendants of slaves. This was created, you guys. The 14th Amendment was added to deal with the newly freed black slaves. What were they going to be granted? With citizenship. Now, from what I understand, there were 2 states that were willing to give the newly freed black slaves full, sovereign, free state citizenship rights. New York, believe it or not, and I forget the second, New Hampshire or Maine, one of those, I'm not sure, but anyway, I didn't have time to go back and look it up, but I know New York for sure were willing. That's what this is all about. As always, comes down to us, black folk. Let me give you this. The California Government Code on the right, Section 242, defines who is a citizen. Remember that the District of Columbia is not a state of the Union, but is the seat of the government, and you, as a U.S. citizen under the so-called 14th Amendment, are a citizen of the District of Columbia. Here it is. Sovereignty of the state. 242, non-citizens. Persons in the state, not its citizens, are either citizens of other states or aliens. This next part is saying, I'm glad that you all agree that you can't be both at the same time, because the Federal District Court in San Diego ruled in 1979 that federal law only protects and applies to foreigners, persons, and aliens, and does not apply to citizens. Now, if you are a citizen, you are exempt from all federal laws, but subject to the national laws. Now, aren't you glad you got a Social Security number so you could become a subject of Congress? And you voluntarily contracted away your citizenship to become subject to federal laws. United States versus others. Upon introducing the, I'm sorry, it's kind of blurred here, so the provisions, which eventually became 18 U.C.C. 242, its sponsor, Senator Stewart, explicitly stated that the bill protected all persons. He noted that the bill simply extends to foreigners, not citizens, the protection of our laws. He added, this bill extends the equal protection of the laws to aliens so that all persons who are in the United States shall have the equal protection of our laws. Just evidence, compelling evidence that I'm trying to share with you. In 1927, the California Supreme Court made the ruling on the right. Read number 2 in the right column. This case has been before the U.S. Supreme Court twice so that it could be overturned. Both times the court has upheld the determination made in this case, and the rulings cannot be overturned as it is constitutionally correct. K. Toshihiro versus Jordan. Citizen. United States citizenship does not entitle citizens to the rights and privileges of state citizenship. Citizens of the United States does not entitle citizens to privileges and immunities of citizens of state, since privileges and immunities of one are not the same as the other. Let's see. So just skip it around. Just hopefully this is making some sense and looking at how they've tricked us. Let me read this part here. This is out of the Federal Reporter. I guess this is Richards versus something. Oh, Richards versus State, I think. Anyway, forgive me for some to read it because it's blurred. Some of it is faded and what have you. So I apologize to you for that, for certain words that I missed or because of that. But hopefully you're able to see it. In our country, the people are sovereign and the government cannot sever its relationship to the people by taking away their citizenship. 387 U.S. at 257. So the court held that a United States citizen possesses a constitutional right to remain a citizen unless he voluntarily relinquishes that citizenship. That's simply getting into reclaiming your sovereign state citizenship. And the other big thing too that people don't understand, and I'll read it to you, is that each state, each common law state is a country. That's why you have different laws in the different states where it's because it's a different country. Let me read it. In 1988, Congress passed Title 28, Section 297. The law is in keeping with the intent of the Constitution. Do you know what the freely associated compact states are? They are the 50 states of the Union of the several states. Read Section 297, paragraphs A and B. What did Congress identify California state as in paragraph? Countries. Remember that each state of the Union is a sovereign state that is equivalent to Germany, Japan, France, or Belgium, etc. We band together for the limited purpose and made the U.S. Constitution a limited grant of power and a restriction upon the federal government. And reading in here, just talk about the judges and any duly constituted courts of the freely associated compact states of reimbursement from the countries referred to in subsection. So that's what it is. And this next part, just because people talk about it, the fringe on the flag, when you walk into the court and you see that, they are not, I'll read. You have seen the fringe flag in schools, courtrooms, and all government buildings. For you, those of you who don't know, you see that there's a flag sometimes. It doesn't have this gold fringe around the whole flag. Well, people were saying, well, do you know what this means? No, it does not mean admiralty maritime jurisdiction as you have been told in the past. Although that is what's going on, and we'll get into that whole thing with common law versus maritime jurisdiction or whatever. No, what it is, and I'll read it to you. This is the flag, some type of United States code or what have you. Interpretive notes and decisions. Placing a fringe on national flag, dimensions of flag, and arrangement of stars in union are matters of detail, not controlled by statute, but are within discretion of President as Commander-in-Chief of Army and Navy, 1925, 34 OP Attorney General 483. That's what it means. So I just wanted to give you, that, understanding of this whole thing with the U.S. citizenship. And see, it was all not a huge issue until the 14th Amendment came about, which was proposed in 1866 and was ratified in 1868. Now, let me say this. This is my feeling and my part on it. Let me first read it to you. 14th Amendment, citizenship, representation and payments of public debt. Citizenship, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's what this all comes down to. They've changed the wording. Persons now, the citizen is small c, resident or reside, see? This is at the conclusion of the Civil War. Now, like I already explained to you about the newly freed black slaves. Here's my question, because you have people who debate and say that it didn't change your citizenship status or add a new one. Here's my question to those people who say that. The Constitution was signed in 1787. What were people prior to 1868? George Washington, Abraham Lincoln, Thomas Jefferson, Ben Franklin, all these people. What did they refer to themselves as? Because they weren't calling themselves, I'm a United States citizen back then. My thing is look, why did they wait nearly 100 years to add this amendment to define what citizens we all were? People already knew what they were, right? I'm assuming, or guessing, prior to 1868. it was 81 years later, from 1787 to 1868, that this was amended to now tell you what type of citizen you were. To me, there's some trickery in there. And at the very least, when the first 10 Bill of Rights were added, that was all done, the first 10 in 1791. That's still 77 years later, you know, that they added this 14th Amendment. Because they intended to create a new class of citizen with the trickery of trying to tell you you're a U.S. citizen, you're just a U.S. citizen, this and that. That's the way I see it. It did change something, and it changed a lot. And we'll go into that when I show you different things and that you sign every day, or not every day, but that you sign and put that you are a citizen of the United States. So hopefully that explains a lot to you, and I know that was a little dry and long, but I hope that, like I said, it was very informative. The next part I'm going to go into, I guess I'm going to call it Part 3, the Social Security fraud, and we'll cover, start getting into the exact things about Social Security. Stay tuned. Hi, welcome back. This is Part 3, called the Social Security fraud. Before I go into that, I want to go back and correct myself for Part 2. I made some incomplete, I guess, sentences. I didn't finish what I was trying to say, and I'm known to do that. Sometimes I get a little ahead of myself when I'm speaking. And what I wanted to finish saying was, I would oftentimes get a call from an coworker or something, or someone that I was an acquaintance of a year later, and they call me up, "Hey Kevin, remember me? You know, Mark, I moved to Florida, and remember how I used to laugh at you about all that state citizen sovereign stuff and this and that? Well, I've met up with groups, or a group down here in Florida, and they're talking about the same things that you used to tell me," and so forth. Or I get a call from someone saying, "Hey, remember me? You remember how I used to laugh at you about, you know, that you have to pay taxes and this and that, and but now I have an issue, you know, they're coming after me. They've sent me notices and trying to do this to me or that. Can you help me?" That's what I meant to say, and to complete my, what I was trying to tell you before. And the other thing too was a word that I butchered badly, and the word is analogous, and I apologize for that, because sometimes, like I said, reading a lot and then my throat getting dry, and I mispronounce a word here and there, and I already told you that would happen or whatever. So and there are some of the words that I was saying that I don't know, even sometimes the meanings are old. They have meanings that go way back in English language and so forth, and I've looked it up maybe a time before but forgot the meaning of it. But analogous is one of those words that's kind of something you don't hear a lot anymore. But anyway, aside from that, what I'm about to get into now is the meat. All right, we already have the potatoes, but this is the meat, and this is where that whole sovereign citizenship and enslaving us and trapping us comes in. Bear with me on this. It's going to be a little bit dry reading again, but I don't want to call it dry reading because it's actually very informative. That's a better word or way for me to say it. This is very informative. So bear with me. I wanted to cut down on it, but I just there's nothing I can cut down on. I mean, it's that deep. 3 pages. So anyway, here we go. Please follow this. In the history of the United States of America, there is probably no more dramatic demonstration of deliberately designed misinformation than the literature put out by the Social Security Administration. One need go no further than 3 decisions handed down by the United States Supreme Court, 2 in 1937 and 1 in 1960. To realize what blatant deception the current Social Security literature contains. These cases are Stewart Machine Company versus Davis, 301 U.S. 548, that's in 1937. Helvering versus Davis, 301 U.S. 619, 1937. And the last, Fleming versus Nestor, 363 U.S. 603, 1960. These cases clearly enunciate the position of the Supreme Court on the Social Security Act and the actual legal position of those who expect to receive benefits from it. Highlights of these cases are as follows. The payroll deductions of workers do not go into a pool or trust fund, but the proceeds of both the employee and the employer taxes are to be paid into the Treasury like other internal revenue generally and are not earmarked in any way. That was the Helvering versus Davis. The court points out that payroll deductions of American workers are not payments on premiums for insurance of any kind, but are simply income taxes. Eligibility for benefits does not, in any true sense, depend on contribution through the payment of taxes. Fleming versus Davis. Furthermore, payment made by employers for each of their employees are not matching to be credited to the account of the employee, but constitute an excise tax of the employer's right to do business. Consequently, his so-called contributions go directly into the general fund of the Treasury, and people participating in Social Security payroll deductions do not acquire property rights or contractual rights through their payments, as they would if they were paying an insurance policy or contributing to an annuity plan. Simply put, there are no guarantees. The Congress does have power to deny benefits to citizens even though they have paid U.S. taxes. Also, the amount of benefits granted are at the option of Congress. Fleming versus Nestor. Benefits guaranteed under Social Security are therefore not considered earned by the worker, but simply constitute a gratitude or gesture of charity. As the court states, Congress included in the original act and has since retained a claim expressly reserving to it the right to alter, amend, or repeal any provision of the act. Fleming versus Nestor. In effect, Social Security benefits are unlike pensions to be given or withheld at the discretion of Congress. Payroll deductions which a worker pays, a special kind of employment income tax, do nothing more than qualify him for consideration as a recipient of a charitable gift. His payments do not guarantee him anything. They do not guarantee the amount to be received, nor the duration of the gift. The Congress can alter or abolish the entire process at any time. Justice Hugo L. Black, dissenting in the Nestor case, stated that the whole Social Security thesis, as expounded by the majority of the court, is that the government is giving the participating citizen something for nothing, and Congress can stop doing so when it pleases. He further stated, I cannot believe that any private insurance in America would be permitted to repudiate its matured contracts with its policyholders who have regularly paid all the premiums in reliance upon the good faith of the company. Fleming versus Nestor, Supra, Justice Black dissenting. It was only a short time after the Supreme Court had revealed that Social Security funds are paid into the Treasury like other internal revenue generally and are not earmarked in any way, and that the Social Security Administration went right ahead publishing literature fraudulently proclaiming that payroll deductions are strictly accounted for and kept separate from the general fund of the U.S. Treasury. Quoted by Warren Shore, Social Security, the fraud in your future. The McKinley Company, New York, 1975, page 23. Literature from the Social Security headquarters also continued to talk about its insurance plan and the contributions which are pooled in a trust fund. All of this was deliberately misleading in view of the Supreme Court's decision cited above. Had a private insurance company so grossly misrepresented its position in this same manner, its officers probably would have been sent to jail. Ever since 1935, the Social Security Administration has laid such great emphasis on its trust fund that the average citizen believes that his benefits are paid out of this fund. The administration knows this and is not true, since benefits are paid out of the general treasury. It therefore relies to its so-called trust fund as a reserve of assets to back up the Social Security program. What this revenue fund amounts to is simply an accumulation of United States bonds which wouldn't pay the liabilities of the system even if they were to be cashed in tomorrow. Furthermore, a government bond is nothing more than a claim against the American people for taxes not yet collected. This is also true of the interest which must be paid on the bond. Neither the bond nor the interest to be paid on it constitutes an asset in any real sense of the term. For a government agency to accumulate a quantity of the government-owned bonds and call these a reserve of assets is like a man writing himself a bundle of IOUs and listing them as assets on his financial statement to the bank. People tend to think of a trust fund as more or liquid funds which have an available cash flow if needed. The Social Security system has no such funds. Unfortunately for some, and tragically for others, the words of Warren Shore describe the real situation. Obviously, there is no pool, just as there are no trust funds. Both words remain in the Social Security lexicon not because they are true, but because they help foster the public notion that Social Security is like insurance, with its premiums, pools, and trust funds regulated to support the promise made. Because all funds collected in the name of Social Security are never earmarked for any special use, they are intermingled with and spent each year like any other funds. This means that billions of dollars collected by the Social Security Administration in the early days of the program were used during 1935 to 1945 to help finance the military requirements of national defense incidental to World War II. Since the war, funds collected in the name of Social Security have continued to be spent on all the miscellaneous appropriations of the government, including foreign aid, salaries for nearly 3 million federal employees, and various regulatory agencies of government. In recent years, there has been a considerable talk about the Social Security system becoming insolvent and getting close to bankruptcy. The government itself is largely to blame for this misconception because it has used this line to justify the gigantic leap in Social Security taxes. They said these increases were absolutely necessary to keep the system sound. And at the same time, excuse me, the Social Security Administration has been promising tremendous increase in benefits if the people would tolerate this new wave of increased taxes. In reality, what Congress really accomplished was create more resources for the general fund of the Treasury for political giveaway programs. The scare tactic of a bankrupt Social Security system has been immorally used against aging Americans to minimize resistance to the new tax gouging in the name of Social Security. The main thing to keep in mind is that Social Security cannot go bankrupt in the ordinary sense of the term because it is able to depend upon the government power to raise revenues by compulsory means through taxes rather than a trust fund such as insurance companies are required to have. As long as the people will allow Congress to tax and tax, spend and spend, elect and elect, the people are too damn dumb to understand, according to the political formula of Harry L. Hopkins as administrative assistant to Franklin D. Roosevelt. Social Security will continue to be a runaway spending program. The Social Security Board of Trustees emphasized the power to tax as a secret weapon in 1972 report to Congress by stating, because compulsory Social Security insurance is assured of continuing income, it does not have to build up the kind of reserves that are necessary at all times in an institution that cannot count on current income to meet obligations. The Taxpayer Federation immediately issued a press release stating, "It is now publicly acknowledged that all adherence to sound insurance practices have been abandoned. This single decision assured ever-mounting tax bills for the system without any possibility of relief. It is the ever-mounting tax bills which constitutes the greatest threat to the Social Security system. And by 1980, the threat has become terribly real." 58 years ago, the federal government created the Social Security program in 1935. It was a new government program for American citizens. It did not then and does not now include all citizens. Some groups such as railroad workers, certain professionals such as doctors and lawyers, and also government employees, including members of Congress, are not members of the plan. Until just recently, certain religious groups also were not members of the program. The government program for U.S. citizens' Social Security is literally called the Federal Insurance Contribution Act, or is frequently abbreviated as FICA. As with some of the other government program names, the actual name is not totally correct and is somewhat misleading. The FICA program is not an insurance plan in the commonly accepted fashion, as there is no guarantee that the citizens will receive certain benefits. A private insurance policy must have protected and positive benefits for its members. The word insurance in FICA is not a correct description, as Congress has total control over the amount as well as the duration of the benefits. Collections or payments can be changed at the whim of Congress, which has been done from time to time. The third word in the name, contributions, is also deceptive and misleading. In the various FICA publications, the word donation is commonly used as a substitute for the term contributions. Most dictionaries define these words to mean that something is voluntary, optional, and is not mandatory. The simple fact is that the FICA program is voluntary and optional. No law has been passed requiring any state citizen to enroll in or subscribe to the FICA program. Remember, classes of workers such as government and railroad employees are exempt from joining. There is strong influence and coercion to make everyone enroll in the FICA programs, but there is no requirement that it must be done. Joining the program is voluntary, and the right not to enroll is protected by the United States Constitution. Described another way, a FICA number, or Social Security number, cannot be forced upon any state citizen, but must be requested by you. Usually a FICA number is requested and received when the state citizen is legally a minor. A minor. There is a question of validity of such actions, as minors are not allowed to participate in contract, especially one that has a lifetime application. Other groups officially exempt from FICA programs are non-profit organizations, also hospital employees, farmers, commercial fishing boats, international agencies like the UN, workers at tax-supported universities, schools, and workers at any tax-exempt entity generally do not have to participate. Preachers, pastors, priests, rabbis, and monks do not pay FICA taxes if they choose not to. To withdraw from FICA as a group, notice of intent must be presented to the IRS 2 years in advance of the actual withdrawal action by the group. As a reflection of the fading confidence in the FICA, there is a growing increase of notices to withdraw, such as the state of Alaska, which was refused. Besides the obvious unreliability of the FICA program, the recent increase in contributions rates is another reason for citizens to consider ending participation. In many cases, workers have more withheld from FICA than for income tax. Currently, the so-called average worker works for more than 1/3 of the year for the government. Based on these two deductions alone, originally, and FICA membership card carried a warning that the card was to be used by the Social Security Administration and not to be as identification. Since then, the warning caution has been removed from the card and the number has become a common identification for items such as banks, driver's license, etc. The Social Security program has various examples of a double standard. One such example is amounts will be withheld from a worker even if he does not have a FICA number. But there is no such requirement to withhold from a state citizen. The law does not require a state citizen to have an account number but collects a contribution from compensation unless the worker is in some class status that is officially exempt. One method to be exempt from payment to the FICA by withholding is a work under contract which specifies that all compensation be received and there are no deductions for any purpose. The state citizen's right to contract is protected by your state constitution and in the U.S. Constitution, Article 1, Section 10. Such financial contract agreement is beneficial to both worker and workplace. The workplace has reduced bookkeeping costs and does not pay matching amounts toward FICA. The company, having reduced business expenses by avoiding FICA costs, could invest such amounts, experience an increase in profits, or share the amount with workers, etc. Such working agreements are within the state citizens' rights, which were established over 200 years ago. A state citizen cannot be subject to government programs that infringe upon rights such as FICA. The collection of FICA tax is accomplished by the IRS. The code book for the IRS is Title 26 of the United States Code. This code, 26 U.C.C, is pertinent to income tax. Income tax is an indirect excise type of tax. This specification is defined in Congressional Report 80-19A dated January 17, 1980. Unlike a direct tax, an excise tax, which is indirect, is the result of having or using a special license or privilege that is granted by government such as U.S. citizenship. If a state citizen does not have or use special license or privilege, they are not subject to an excise tax. Some state citizens are confused about the income tax and believe a tax is owed the compensation, wages, salaries, and commissions received by them for performing some service. Careful study of this subject reveals that opinion to be incorrect. There is a tax on income, but it does not include wages, salaries, tips, commissions, etc. This is so stated in the IRS code itself, which describes FICA tax in section 3101 of chapter 21 as follows. Rate of tax A. In addition to other taxes, there is hereby imposed on the income of every individual a tax. This type is an indirect tax and has been so ruled by the Supreme Court in Hovering versus Nestor, in which it states that the employee's portion of Social Security is an income tax and is not a premium payment for any kind of insurance program. Notice also that in section 3101 of 26 United States Code separates and distinguishes a difference between income and wages. This means the amount of withholdings, contributions are determined by wages earned. However, contributions withholdings are not required until a state citizen earns an income. This statement is very important to the proper understanding and application of the FICA tax. Simply put, if state citizens do not receive income, which is profit or gain, they are not subject to deductions for FICA. This is the same authority used for tax on income. Liability for FICA is not the result of being a worker, but is based upon the condition that the worker receives a profit or gain, income. Section 3102B of the 26 United States Code strongly influences employers to contribute and withhold FICA tax from their workers, attempting to make the workplace responsible for the tax if the worker decides to halt withholdings volunteering. Many citizens are confused about what income tax is and believe it to be a tax on compensation, wages, salaries, and commissions received by them for performing some service. This is untrue. There is a tax on income, but that tax does not include taxes upon wages, salaries, tips, compensation, etc. Taxing these categories was automatically repealed in 1946 when it was ruled that a tax on the source, wage, etc. can only be levied for a term of 2 years once our government declares war per Article 1, Section 8, Clause 12, United States Constitution. This is also indicated in the IRS Code itself, where it describes the FICA tax in Section 3102 of Chapter 21, which reads as follows. Rate on tax A. In addition to other taxes, there is hereby imposed on the income of every individual a tax equal to the following percentage of the wages. The government is admitting in Section 3101 that income is income and wages are wages. The word income and wages have two different meanings, thus are not income and cannot be taxed. Notice carefully that 26 United States Code 3101 also specifies the FICA contributions are taxes. That FICA contributions are taxes. This is an indirect excise tax and has been so ruled by the Supreme Court in Fleming versus Nestor for employer's portion, commonly called the matching half. This tax liability directed at the employer is the result of business operations permitted by government. We already went over that. And actually, this is just just going over the highlights of what I just read everything to you. So I didn't realize that, but I'm not going to go ahead and continue reading that at this point. Did you get all that? That's deep. That's the meat. That explains all in all what's going on. And I hope that you understand that, because this is what's happening in this country. They've lied to you and us, or us. For those of you who are, I'm going to say older than me, but you know, I've seen it in people like my parents and so forth. On there, in cards that were first issued. On there, this is some research that I did years ago when I went and looked up newspaper books from like the early 1900s and different things. Social Security enacted. On there, you can see it says on the bottom, for Social Security purposes, not for identification. It's on the bottom of that. And I've seen it on actual cards, and then they took it off. What do they want from you now? Every time you go and you get us do something, they want what? They want a Social Security number. And I'll show you all that. Just let me read this article to you that was done in 1935. It's just interesting historical purposes or history. August 14th, 1935. President Roosevelt signed into law the Social Security Act today, fulfilling a 1932 campaign promise. In that year, the Democrats pleaded, "We advocate unemployment and old age insurance under state laws." Now America joins many other industrial nations in providing comprehensive care of its elderly, handicapped, and unemployed. Payroll taxes will fund the legislation which has taken over 14 months to enact. Conservatives have fought the bill since FDR proposed it last June. One congressman believes the bill would threaten the integrity of our institutions. But the majority of the Congress feel it will relieve the burden of many Americans. Why? Because they created the stock market crash. They created all of this. This was all in plans to get us under control or under contracts of slavery. And you don't have to have a Social Security number. And I'll get into this when I get into like actually presenting this information to your workplace for your job. There are some other parts I want to read to you. I totally forgot. I was gonna share with you on it, but I'll skip it for now and go into this, because this is part of it, what I'm talking about with your workplace. I want you to read this. It's not too long, but this is what, and like I said, we'll get into it later, but just hear this out because it's very important. This is one of the letters that I used with jobs and so forth. To whomever this may concern regarding the use of Social Security numbers as a condition to work. A citizen is not required by law to possess or use a Social Security number. The IRS cannot issue penalties against companies which fail to furnish a taxpayer identification number or Social Security number for their workers when filing company returns. The code allows an omission for a reasonable cause. A penalty will issue willful neglect to request such identifiers. A penalty is not normally assessed for de minimis failures. Following are some facts which should completely resolve this dilemma. There are 3 sections of the IRS code which applies to the circumstances in question. They are 26 U.C., United States Code, U.S. Code, United States Code. Section 6109A3, 26 U.S.C., Section 6721A, 2B, Section 621C, 1B, and 26 U.S.C. Section 6724A. These passages came about for the most part as a result of the passage of Public Law 101-239 on December 19, 1989, the Omnibus Budget Restoration Act. The Internal Revenue Code sections referred to above support the policy that the company is merely to request the worker to provide the company with his SSN or TIN number. See Section 6109A3. If the worker does not provide the number for any reason, regardless of what it is, the company must obtain from the worker a written explanation for inclusion with the company tax returns. If a penalty were to be imposed under Section 6721A2B for that omission, that penalty would be unlawful and would constitute harassment. In the event the company submits a few returns with identifiers omitted, then Section 6721C1B would apply. The penalty provided in Section 6721A is a nominal $50 for an incomplete return, and that is considered to be a de minimis failure. Section 6721C, the de minimis failure doctrine as defined in Black's Law Dictionary, states, the law does not care for or take notice of very small or trifling matters. The law does not concern itself about trifles. The IRS would not normally go to the trouble of imposing penalties on a company which omitted a few identifiers when supported by worker statements. This would be a de minimis failure which would fall under Section 6721C. In connection with requirement Section 6721C1B, we must additionally consider Section 6724A, which states that no penalty shall be imposed if it is shown that such failure is due to a reasonable cause and not for willful neglect. The probability of an assessment is remote. However, if a computer-generated automatic assessment is sent to the company, a simple letter of explanation will suffice. In that case, the company should state that the identifier was requested but not provided, and refer to the copy of the affidavit sent with the return. This procedure will be sufficient to waive any penalty pursuant to Section 6724A. The employer or workplace needs only to furnish the information provided him by the worker and then pass it on to the IRS as described above. The provisions of the Internal Revenue Code only appears to require that which is actually voluntary. As you have read and seen, the provisions of the Internal Revenue Code noted above are that an affidavit will resolve this apparent conflict. In the event you feel more comfortable about the matter, I agree to sign a hold harmless agreement with you. Such an agreement would state that I will assume personal responsibility for any penalties wrongly imposed upon you for failing to obtain a Social Security number. See me for the conditions of this agreement. That's just a letter form that explains it right there. That's why you don't need it. But through the coercion of the Social Security Administration, of the government, people think they have to have it. It's not true. Let me move on quickly because I've already taken enough time. I just want to show you some facts or some very interesting things. Here are some letters in my possession dated July 16, 1986. And just to read it to you real quick, the highlights of what it says. I'm not going to read the whole letter, but these are letters in response about people questioning the government on taxes, or Social Security numbers, and taxes for that matter. Here we go. This is just the highlighted part. Workers who do not wish to use their Social Security numbers for religious or other reasons should get in touch with the Internal Revenue Service office in their area to explain their position and receive advice on how to proceed. It just told you it right there in those sections where it explained to you about not providing the number. We do not have the authority to require an employer to provide or deny employment or services to anyone who refuses to disclose his or her number. This is a matter between the individual and employer. We hope this information is helpful. This was done by, signed by Dorcas R. Hardy, Commissioner of Social Security, back in 1986. The next letter was from 1981, the United States Senate. And it says this, just to show you the letter, so you don't think I'm... There is no Social Security law requiring that one have a number, but the IRS Tax Code, Section 6109, subsection A, stipulates that taxpayers shall utilize their Social Security numbers when filing tax returns. Therefore, if one pays taxes, one must have a Social Security number. If I could be of assistance of another matter, please do not hesitate to contact me. Sincerely, Lloyd Benson. Did you catch the lingo in there? This is what we're telling people. Stipulates that if one is a taxpayer, he has to use it. And if not, we all have to pay mandatory. If, because they know you don't. These people know. All right, enough on that. Let me move on. So just showing you, I've been in the battle for a long time, and I just want to show you some things. Back when I did kind of rescind my Social Security number and fighting with these people, anytime you go and fill out stuff, you need to put like stuff like this, like on the Social Security applications way back in the day, right? I put down there, like I was just testing it out and just seeing what they say and how they do stuff. I put down like my sovereign address and everything, and I put it like for a replacement card or something, right? Yeah, it was for a replacement card, if I remember right. And this is what I did. I signed it, and I had protest remarks. Signed under protest, objection, and economic duress because of my religious and political beliefs. So on this, you can't see it, but it states, you know, has this person ever had a Social Security number before? You can't lie and say no if you have. Then it says on there, citizenship, U.S. citizen, legal alien allowed to work, legal alien not to work, etc., and other. So I put other, because I am not, in the word, they use it interchangeably on this. U.S. citizen or citizen of the United States. That's the slave citizen. Okay? I put on there, and it says right here, it's kind of funny, they don't give you anything for a state citizen. See, that's how they try to keep this hidden. If you are not a U.S. citizen, you must show us your birth certificate or passport and the documents given to you by the Immigration and Naturalization Service, INS. We must see original documents, not photocopies. Examples of INS documents are your alien registration receipt card, form, or Form 1 I-94. Because these documents should not be mailed, you should apply in person. Even though you may not be authorized to work in this country, we can issue you a Social Security card if you are here legally and need it for some other reason. Your card will be marked to show that you cannot work, and if you do, we will notify the INS. See, this is funny. So on that, I've done this a couple times. They sent this this letter, and they say, when I signed it like that, we are unable to process your application for Social Security number because you have not provided adequate evidence of your age, identity, and or U.S. citizenship or lawful alien status as requested. And they put down here, failure to cooperate on this letter. It's just kind of funny how they do it. Just showing you. And here's another one that says, we are unable to, Social Security denial notice at the top right there. And it says, we are unable to process your application for Social Security numbers because other. Applications cannot be processed with protest remarks. Citizenship must be identified. So it's just kind of showing you some of the battles. And I want to show you some of this. On your voter registration, it asks in red, are you a U.S. citizen? It asks right there. Yes, no. If no, don't fill out this form. It's right there. There's been a battle with the driver's license in the state of California. And I've gone to court suing the DMV over this issue. Social Security number, right here at the top. Social Security is required before an original identification card application is started. Social Security number is verified before any original commercial driver's license. A what? Commercial driver's license. They're all commercial driver's license. Application is started. They're trying to trick you on that and make it like it's something different when it's actually not. And it says right here, it's funny, Social Security number collection disclosure. Authority to collect the Social Security number is 42 U.C.C. 405 and California Vehicle Code. I'm not going to read it all. It will be used in the administration of driver's license laws and motor vehicle registration laws and to respond to requests for information from the Franchise Tax Board. Yeah, my good old buddies, right? For tax administration and from any agency operating pursuant to 42 United States Code 601 ET SEQ. It will be used to aid in the collections of monies owed in connection with failure to pay fines or failure to appear in court by an applicant, and to aid in the collection of monies owed by an applicant in connection with aid to families with dependent children, child support, and establishment of paternity. You are required by law to provide your Social Security number on your app, or your application will be denied. I forgot what the conclusion was, that it really is not a law. Or not, I'm not sure, but just showing you things like what they're doing. Social Security numbers were never meant to be used for anything other than Social Security purposes. How did they end up being used for driver's licenses? Because they do stuff like this. Credit cards, medical records, and stuff. It's gotten crazy. Here is a Wells Fargo Bank account, customer information, federal tax information. I found this pretty interesting and funny how people can come here and not use this. Foreigners. Well, they're kind of, if they're going to be a U.S. citizen, they can't be a sovereign because they weren't naturalized or naturally born here. So I don't quite understand that. But anyway, because people pointed out that foreigners come here and they get bank accounts all the time without Social Security numbers. Well, you're supposed to too, because you are not a U.S. citizen. But here it is. You read this. Check this out on this application for a bank account. Federal tax, your Social Security number or taxpayer identification number. Yes, I am subject to backup withholdings. No, I am not subject to backup withholdings. By certifying that I am not subject to backup withholdings, I have to certify that I am not subject to backup withholdings, either because the IRS has notified me that I am no longer subject to backup withholdings, or I have not been notified that I am subject to backup withholdings because of failure to report all interest and dividends. Note, Wells Fargo policies require that a taxpayer identification Social Security number be obtained for all accounts open. This number should be the number under which the bank will report the interest earned to the Internal Revenue Service. Non-resident alien exemption. We are claiming the non-resident alien exemption. Under penalties of perjury, I certify that I am neither a citizen nor resident of the United States. See? Therefore, no taxes. or something like that. Now, when I say no taxes, let me say this. I took classes, on like investments and, mutual funds or whatever, and they said that one thing you can do is if you don't want to use a Social Security number, that they can just tax you, take the tax out because it's income. Remember, if you're earning interest on your, your stocks or bonds or whatever, your mutual fund, your investment, the government's going to take that interest because that is legally called income. So they're going to take that. But I was told that they'll just take a straight, 30%, something like that. If you don't want to use your Social Security number, don't want to deal with it, just let them take it. It's just like you go to Vegas and you win $100,000 and you don't want to give them a Social Security number. Just tell them, look, just take what you take. Take your 30%, give me my 70 grand, let me walk. I ain't filling out Social Security numbers and government forms and all that stuff. 'Cause that's how they track you. So keep that in mind. And banks are the worst. Get me on that. You shouldn't even be banking for any reason with a bank. There's no purpose for that, for a bank. Maybe I'll do a thing about that later. But let me move on. Another thing is, I don't remember the exact reason. I'm not sure if it was a lawsuit or something, but I just want you to see this because I got it highlighted. This is a Taco Bell application. On that application, if you can see on the highlighted yellow, it says Social Security number is optional. There was some issue with that where they got sued or something like that, and they had to put that on their application because you don't need a Social Security number to work. That's evidence right there. There was a pretty big case back in the early 90s called Equal Employment Opportunity Commission Plaintiff versus Information System Consulting, a division of Diversified Human Resources Group. In this, the person was saying he doesn't want to give a Social Security number. And they lost their case, by the way. This person won like $10,000 for being discriminated against. If I remember right. The defendant, settlement of this dispute, back pay an amount of $10,000 to Bruce Hansen. And this is what I want to read to you, the highlight part. The defendant, Information Systems Consulting, a division of Diversified Human Resources Group, shall be permanently enjoined from terminating an employee or refusing to hire an individual for failure to provide a Social Security number because of religious beliefs. If an employer or applicant for employment advises the defendant that he does not have a Social Security number because of his religious beliefs, the defendant shall request, pursuant to Section 6721 of the Internal Revenue Code, 26 U.S.C. and 6724, a waiver of any penalties that may be imposed for failing to include an employee's Social Security number on forms and documents submitted to the IRS. In the event the waiver is granted, the employee shall be treated the same as all other employees. Now, I know I've explained to you what the wording they use, employee and this and that, because the courts already are going to make the assumption they're never going to look at you as a free sovereign person. They're always going to use that wording. So, you can correct them and let them know, I'm not an employee. I work, or whatever. But you see that case? How come you don't hear about this on the news? Or any of the other cases that the IRS have gotten their butts whooped? Yeah, because they don't want you to know about it, because they're all in cahoots with the Illuminati and Freemasons and the corruption and the lies in this country. That's why. All these news channels, Fox News, CNN, all these people, they're all in cahoots with it. And I'm tired of it. And it's time people wake up, because I've been telling this stuff for years. I'm tired of hearing the ignorance from still coworkers and people. I'm tired of it. It's a fallacy. It's a lie to trick you and to deceive you. Now, I'm not even going to read all this, but this was my battles with the Social Security Administration back in the day and getting Mr. Brad Sherman, congressman, involved. Not really impressed by that guy. That's why I did that. But I had to call him and write him to his office because I had sent off questions to the Social Security Administration. And I'll get into this later in another part. But they hadn't responded to me in months. And I didn't like that. And I was asking them to please respond. So they didn't. So I got Brad Sherman, contacted his office. He didn't directly deal with me. But anyway, I got in contact with his office. And I'm going to read some of the letters to you. My video's about ready to run out. So I got to go to the next part or edit it and talk to you about the letter. So I have a couple minutes left on the same thing, so let me go real quickly. So, in other words, the Social Security Administration, okay, what happened was I sent it to them and they didn't respond for 4 months. So I contacted Brad Sherman's office to get them to make them respond. And this is one thing that they said to me, that they told me. The Social Security office did receive your letter, but that they had misplaced it. So I faxed them a letter again on May 15th. I'm sorry. I faxed him a letter again. So this is what the Social Security said to me. Apparently, Mr. Perteete did not find our earlier letters responsive to his concerns. They've never sent me letters before that. This is the first time I've ever heard from them because they never responded. Mr. Perteete appears to be one of a growing number of correspondents who want to disassociate themselves from the Social Security programs. These inquiries typically question the constitutionality of the Social Security program, their identification as citizens of the United States, the validity of their Social Security numbers, etc. The overall intent of such correspondence is to avoid paying Social Security taxes. And of mandatory, or this is another part of it, so I don't know why I just highlighted, but and of mandatory individual participation in the systems have already been decided by the Supreme Court. See how they answer questions with a bunch of lies. The overall intent of such is not to avoid paying Social Security taxes. It's to avoid having to have a Social Security number, period. It's not just about the taxes. But see, they try to turn it on you as if, oh, the only reason they still want their number, but they just don't want to pay the tax. No, I don't want the number, and most of us don't. But see how they say a growing number of correspondents? Of people. It's their way of telling you. Many people are fed up and are questioning. This was a while ago. So we got to keep the pressure on these people. But it's just funny to me how they think. The overall intent is to avoid. And that's the same thing they say about the taxes. I told you. Yes, that is a big part of it, but that's not the only part. There's lots of parts. The main part is I want to be a free, sovereign state citizen. Free and clear with my unalienable rights and not being contracted and forced or tricked into this federal contractual U.S. citizen stuff. So anyway, I just wanted to share with you because we got into some heavy debates and I don't want to say it got a little nasty at the end, but the guy that was helping me through Brad Sherman's office was telling me he can't help me anymore and he refuses or this and that, and I was trying to explain to him that you work for we the people, bro. I'm not being rude or in any way to you, so you're telling me, that, to say that to me is very offensive, and that that he doesn't wish to harass the Social Security Administration anymore. You're not harassing them, you're asking them simple questions that we as citizens, or we the people, have the right to know. Anyway, that concludes this part, which is part 3. Stay tuned for part 4, the Uniform Commercial Code. Okay guys, welcome back to part 4, the Uniform Commercial Code. And this is another lengthy part, an important part for me to explain to you. I'm going to try to do it as quickly as I can. The Uniform Commercial Code was started in 1942 and completed in 1952. It took 10 years to do this. And they changed over to this code, switching America from what we call public law to public policy. Basically the common law and sovereigns switching over to the slave law and admiralty maritime jurisdiction. That's a simple way to kind of explain what happened. I've learned all of my stuff on the Uniform Commercial Code from what we call a constitutionalist and patriot, a master named Howard Freeman. Howard Freeman was I'm going to say very old man, but at the time he was born in 1900. So, and he passed away in 1992. So the man, if he'd still be alive, he'd be 115 years old today. And he was very knowledgeable. He tells you that he wasn't a lawyer, but I think he worked in the insurance industry, but he was very smart. They look at this man as one of the best teachers, educators in the Constitution for the United States of America and common law and so forth. Okay? Ralph Epperson is the person who did this. This was done in 1990, or taken from Howard Freeman, one of his speeches or seminars. And he, took it from the tapes and all the information and translated it into this book. If you can find this, I highly recommend you do it. Now, I've read parts of this in different videos of mine on my channel. So, but I'm going to go a little deeper and into it as best I can. But here it is. It's a very, I would say, underground book. I don't know where you can even find it. It's called the U.C.C. Connection: Free Yourself from Legal Tyranny, a review of the Uniform Commercial Code, U.C.C., by Howard Freeman, constitutionalist and patriot, reviewed by Ralph Epperson in 1996. So this stuff is, I won't say old information, but this was thoroughly explained by this gentleman back then. And I really, I've learned so much for this. I've had this for so many years. And it was only until 2012 I started I got frustrated and tired, or I won't say frustrated, but tired of police pulling me over for stupid things and bothering me. And I've always known about this, but I never studied it. It was hard. It takes time. It's not something you're going to learn in one day, believe me. It takes time and dedication of yourself to sit there and really understand what is being said here and research it and so forth. And that's what I finally started to do. And that's why I have the videos, excuse me, on me fighting, in court under the Uniform Commercial Code. Anyway, so public law versus public policy. Just to set it up, because this is, a book, so I want to get into the important parts. What Mr. Freeman had found was he was helping a friend in court, and they were quoting Supreme Court cases or cases prior to 1938. The judge ended up ruling against him, and he caught up with the judge, like in the elevator or whatever, and said, "Well, why would you rule against me?" And the judge told him, I don't make rulings. Anything prior to 1938 cases in my courtroom don't apply. Anything after 1938, I will acknowledge and will rule on that." And he didn't understand why, and he was saying, "Well, what's the difference and what's going on?" And that particular judge wouldn't tell him. So what happened was there was a case in 1937, 38, somewhere around there. I mean, it's in the law books. They're saying it's argued January 31st, 1938, called Erie Railroad versus Tompkins. And this is what the judge was talking about, where it went from common law into contractual law. So I'm skipping around, but so Mr. Freeman always told people, look, don't go in the courtroom being harsh and demanding and telling the judge you're going to follow the law, you're going to do what the law, because if you come off like a wolf, and they're just going to fight you back. You got to go in there and play kind of dumb, or be very humble and like sheep, and just listen and say, just play dumb, I guess he's saying. Play a little dumb, ask a lot of questions. So that's what he did. And one day, and I'm going to start reading it. A friend in court from this point on, and I'll try to condense it as much as I can, but there's just so much you got to get here that I can't really condense it. Fortunately, I made a friend of the judge. Now you won't make friends with the judge if you go into court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is and how he had better uphold the law or else. Remember, verses, I send you out as sheep in the wolf country. Be wise as a serpent and harmless as a dove. We have to go into court and be wise and harmless and not make demands. We must play a little dumb and ask a lot of questions. Well, if I ask a lot of questions and box the judge into a corner where they have to give me a victory or admit what they didn't want to admit. I won the case, and on the way out I had to stop by the clerk's office to get some papers. One of the judges stopped me and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case, we will visit." America is bankrupt. Later, when I went to visit the judge, and this is Ralph Epperson, he quotes and fills in gaps or what he feels. Epperson, I can remember that during one of our meetings, Mr. Freeman revealed that this judge was in actuality a retired state Supreme Court justice from his home state of Wyoming or Montana. He further stated that this judge had asked him not to reveal his identity because he could get in a lot of trouble by revealing too much. I told him of my problems with the Supreme Court cases dealing with public policy and public law. He said in 1938, catch this, and I've already read this before, but in other videos, but this is deep. He said in 1938, all the higher federal judges, the top attorneys, and U.S. attorneys were called into a secret meeting, Epperson, by President Roosevelt. And this is what the president told them. The president explained that America was a bankrupt nation. It was owned completely by its creditors. Epperson. The creditors, according to Mr. Freeman at another time, were the international bankers who had loaned America all the money they had created, that had created the national debt. Mr. Freeman explained that the reason they had declared America bankrupt was because this nation had called in all of the gold behind this nation's money and had suspended the redemption of paper money into gold, and was required by the very money the American people and the bankers were carrying. This meant that this nation had in essence defaulted on our contracts with anyone who owned a gold certificate. This permitted its bearer to exchange the paper for actual gold at any time the bearer wished. So they were declaring this nation to be bankrupt, and since they now owned all of this nation's assets, they were telling this government that they would be required to henceforth adjudicate all cases under the Uniform Commercial Code and not the Constitution, meaning the guarantor of the common law. But they had to make us subject to the jurisdiction of this new Constitution. And they did that through several methods. The passage of Social Security Act. There's no law requiring sovereign state citizens to get a Social Security card, so they trick us by making us think that we must get a card when it is a voluntary act, as I've already covered. The requirements that all babies get a birth certificate. We used to enter the details about the birth of our child in the Holy Bible, and that ended it. In the need to obtain a driver's license, we are travelers, not drivers. And only drivers have to get a driver's license. Car registration, we pledge our car to the state as collateral for the debt we owe the bankers, etc. And I've covered all that. These are called adhesion contracts, meaning a two-party contract in which both parties are obligated to perform some activity. And also, too, from what I understand, the adhesion contract also means it's a contract where you either sign it or you don't. You're not forced to. So, the creditors of the Congress, they own... the creditors own the Congress, right? They own the executive, they own the judiciary, and they own all of the state governments. Epperson. I added the opening phrase of the following comment by Mr. Freeman since this part of my copy of the transcript could not be made out. I believe that Mr. Freeman would have said, we, meaning the federal judges and attorneys, were told to take silent judicial notice of this fact, which means we were to never reveal it openly. We were told that our court was to operate in admiralty jurisdiction and that we could call it anything we wanted, but that we were never or not to call it admiralty law. Admiralty courts. The reason that these judges cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there's a valid international contract in dispute. If you know it is admiralty jurisdiction and they have admitted on the record that you are in an admiralty court, you could demand that the international maritime contract to which you are supposedly a part and which you supposedly have breached be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. You get it? So you say, just like innocent excuse me, just innocently like a lamb, well, I never knew that I got involved with international maritime, so I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then place the contract in evidence so that I may challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every asset of the nation. The reason that they don't want to tell everyone that they own everything is that there are still too many privately owned guns. There are uncooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all of the countries into a single world court, meaning the New World Order, ampersand. There are many who are claiming that the coming New World Order is a world government, or as in this case, a world court. That opinion is simply not correct. In my book entitled The New World Order, I carefully document the evidence that it is a new civilization, an entirely new way of looking at how we live our lives. In other words, those in favor of the New World Order want to change the basic order of things to remake our civilization. See, that's, you know, we have differences of opinion of what it is and what they're trying to do, but in generality, my opinion is, you know what's going on. They're trying to consolidate this into a New World Order and put us enslaved, you know, as slaves and shackles again. You know, it's ugly. Back to Mr. Freeman. It is not expedient to admit the jurisdiction of the court. Excuse me. It is not expedient to admit the jurisdiction the courts are operating under. When we understand these things, we realize that there are certain secrets that they don't want to admit, and can use this to our benefit. Please forgive me for stumbling over it. Just one of those days. Jurisdiction. The Constitution of the United States mentions 3 means of jurisdiction in which the courts may operate. Number 1, common law. Common law is based upon God's law. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please as long as you do not infringe on the life, liberty, or property of someone else. You also have the right to make a fool of yourself, provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any action by the government which prevents a man from making a fool of himself. For instance, when you cross over state lines in most states, you will see a sign which says, "Buckle your seatbelt. It's the law," or "It is the law." This cannot be common law, because who would you injure if you did not buckle up? Nobody. This would be compelled performance. But common law cannot compel performance. Any violation of the common law is a criminal act and therefore is punishable. The next law, equity law. Number 2, equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court, which is a criminal action. Are our seatbelt laws equity laws? Question. The answer to that question is they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Number three, admiralty maritime law. This is civil jurisdiction of compelled performance, which also has criminal penalties for not adhering to the letter of the contract. But this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws and all traffic laws, building codes, ordinance, tax codes, etc. are under. Whenever there is a penalty for failure to perform, such as willful failure to file, this is admiralty maritime law, and there must be a valid international contract in force. Are you getting this? However, the courts don't want to admit that they are operating under admiralty maritime jurisdiction, and also that they had taken the international law or law of merchant and adopted it into our codes. That is what the Supreme Court decided in Erie Railroad case, that court decisions would be based on commercial or business law, and that it will have criminal penalties associated with it. Since they were instructed not to call it admiralty jurisdiction, they decided to call it statutory jurisdiction. You may ask how we got into the situation where we can be charged with where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, he is. But you must understand that the Constitution in Article 1, Section 10 gives us the unlimited right to contract as long as we do not infringe on the life, liberty, or property of someone else. Contracts are enforceable. And in the Constitution, there are two different jurisdictions mentioned where contracts can be enforced. They are equity and admiralty. But we find them enforced in statutory jurisdiction. This is the embarrassing part for the courts. But we can use this to box the judge into a corner in their own court. We will cover this more later. Did you get all that? That's some deep stuff. And that's the basis of all of these traffic courts and a lot of other courts. Contracts must be voluntary. Under the common law, every contract must be entered into knowingly, voluntarily, and intentionally by both parties, or it is void and unenforceable. These are characteristics of a common law contracts. There is another characteristic. It must be based on substance. For example, contracts used to read, for $1, for example, and the other valuable consideration, I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now, suppose that you wrote a contract that said, for one Federal Reserve note and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go to a common law court and get justice? Question. No, you could not. Because a Federal Reserve note is a colorable dollar and therefore has no substance. And in common law jurisdiction, that contract would be unenforceable. So you start understanding the money system. They had to change over to the Uniform Commercial Code to govern the new colorable money, the fiat money, the fake money, because it used to be real substance prior to that with gold and silver. So he'll explain a little bit of that when I tell you. Colorable money, colorable courts. The word colorable means something that appears to be genuine, but is not. Maybe it looks like a dollar and maybe it spends like a dollar, but if it is not redeemable for lawful money, silver or gold, it is colorable. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract. And colorable contracts must be enforced under a colorable jurisdiction. So by creating the Federal Reserve notes, the government had to create a jurisdiction to cover the kind of contract which uses them. Ampersand. It might assist the reader to get another understanding of what Mr. Freeman just said. The Constitution requires the government to issue lawful money, meaning a money based upon gold and silver. A contract that two people signed that dealt in lawful money could be enforced under the terms of the common law when the international bankers were no longer getting their money redeemed in lawful money. The Federal government could not force them into a common law court because they were no longer subject to the terms of the common law. They have the right to move the jurisdiction of all of their cases to another court, a colorable court, where colorable money could be transferred under contracts between two parties. But they had a problem. The people of the United States could not know about what just happened. They could not let them know, or they would rebel and demand a return to the Constitution and lawful money. So they took silent judicial notice of the fact that the court system had changed. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. It is a colorable admiralty jurisdiction that the judges are enforcing because we are using colorable money. Let's see how we got under this statutory jurisdiction. Deep, huh? When you're understanding and you start to get this, it really begins to open your mind and you begin to understand how we've been duped. Uniform Commercial Code. The government set up a colorable law system to fit the colorable currency. It used to be called the law merchant or the law of redeemable instruments because it dealt with paper which was redeemable in something that had substance. But once Federal Reserve notes had become irredeemable, there had to be a system of law which was completely colorable from start to finish. The system of law was codified as the Uniform Commercial Code and has been adopted in all states except Louisiana. I already explained that to you. Or did I? I don't remember if I did. Forgive me. The Uniform Commercial Code, I think I did, said that they fall under a different law system. They fall under Roman or under Roman law and Napoleonic law is what they call it. The state of Louisiana didn't follow the Uniform Commercial Code. Now, from what I understand, they've adopted all parts of it as of today, except two. But so they say, certain things may not work there because of that reason. That's why only the state of Louisiana did not adopt the Uniform Commercial Code, but like I said, most of it has been, now they use it and have adopted it. So just a bit of information. Sorry if I forgot if I mentioned that in the beginning or not. This is called colorable law and is used in all of the courts. I explained two of the keys earlier, the first of which was the country had been declared bankrupt, and the second was that we had no rights. If the master says jump, then the slaves had better jump. because the master has the right to cut off their heads. As slaves, we have no rights. But the creators, masters, had to cover that up. So they created a system of law called the Uniform Commercial Code. This is colorable jurisdiction under the Uniform Commercial Code. This colorable jurisdiction under the Uniform Commercial Code is the next key to understanding what has happened. Now, there are some, and I understand, that argue to say that they don't like the Uniform Commercial Code because it was created by government, and it's not something that was considered under the common law. But looking at it, on my view is, yeah, but it allows you to switch it back into the common law. Because at the time, there was no purpose for a Uniform Commercial Code because we were dealing with common law and real gold and silver. But once they changed that, they put this in there to allow the people who knew or know how to do it to switch back this case from amity, maritime jurisdiction, or from that fiat colorable money back into the real common law. So that's my view on it. Okay, contracts or agreement. One difference between common law and the Uniform Commercial Code is that in common law, contracts must be entered into, and you all know this, knowingly, voluntarily, and intentionally. Under the Uniform Commercial Code, this is not so. First of all, contracts are unnecessary. Under this new law, agreements can be binding, and if you only exercise the benefits of an agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. If you accept a benefit offered by the government, then you are obligated to follow to the letter each and every statute involved with that benefit. The method has been to get everybody exercising a benefit, and they think they don't even have to tell the people what the benefit is. Some people think it's a driver's license, the marriage license, or birth certificate, etc. But I believe it is none of these. Compelled benefit. I believe the benefit being used is that we have been given the privilege of discharging debt. We give substance for substance. If I bought a quart of milk with a silver dollar, that dollar bought the milk and the milk bought the dollar. Substance for substance. But if I use a Federal Reserve note to buy the milk, I have not paid for it. There is no substance in the Federal Reserve note. It is worthless paper given in exchange for something of substantive value. Congress offers us this benefit. Debt money created by the federal United States can be spent all over the continental United States. It will be legal tender for all debts, public and private, as it says on its face. And the limited liability is that you cannot be sued for not paying your debts. So they have said, we're going to help you out, and you can discharge your debts rather than pay your debts. When we use the colorable money to discharge our debts, we cannot use a common law court. We can only use a colorable court. We are completely under the jurisdiction of the Uniform Commercial Code. We are using non-redeemable negotiable instruments, and we are discharging debt rather than paying debt. That makes sense. Remedy and recourse. Every system of civilized law must have two characteristics, a remedy and recourse. Remedy is a way to get out from under the law. The recourse is if you have been damaged under law, you can recover your loss. The common law, the law of merchants, and even the Uniform Commercial Code all have remedy and recourse. But for a long time, we could not find it. If you went to the law library and asked to see the Uniform Commercial Code, they would show you a shelf of books completely filled with the Uniform Commercial Code. When you picked up one volume and started to read it, it would seem to have been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse were found in the Uniform Commercial Code. They are found right in the first, volume at U.C.C. 1-207 and U.C.C. 1-103. Now, I remember what I told you in the beginning about how they revised it to 1-308. 1-207 is still in effect. You can go look it up and see for yourself. It's still in use, or still is valid. Okay, so just keep that in mind. Now, because I'm reading this at the time before they changed it, so when I read this, understand that I'm reading it as it's written here, without, telling you any more from this point on about the revision of it. Remedy: the making of a valid reservation of rights preserves whatever rights the person then possesses, and prevents the loss of such rights by application of the concept of waiver of estoppel, U.C.C. 1-207.7. It is important to remember when we go into court that we are in a commercial international jurisdiction. If we go into court and say, I demand my constitutional rights, the judge will most likely say, if you mention the Constitution again, I will find you in contempt of court. Then we don't understand how he can do that. Hasn't he sworn to uphold the Constitution? The rule here is you cannot be charged under one jurisdiction and defend yourself under another. For example, if the French government came to you, not a French citizen, and asked you where you had filed your French income tax in a certain year, do you go to the French government and say, I demand my constitutional rights? No. The proper answer would be, that law doesn't apply to me. I am not a Frenchman. You must make your reservation of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So in a U.C.C. court, you must claim your reservation of rights under the U.C.C. 1-207. That section goes on to say in section U.C.C. 1-207.9, when a waivable right or claim is involved, the failure to make a reservation thereof causes a loss of the right and bars its assertion at a later date. You have to make your claim early. Furthermore, in U.C.C. 1-207.4 it says, the sufficiency of the reservation, any expression indicating an intention to receive rights, is sufficient, such as without prejudice. Whenever you sign any legal papers that deals with Federal Reserve notes in any way, shape, or manner, write this above your signature: without prejudice, U.C.C. 1-207. As I already told you, I have to say it here because I want people to mess up. And now it's U.C.C. 1-308. But you could still say formerly 1-207. When you use this phrase, you are reserving your rights. You can show at U.C.C. 1-207.4 that you have sufficiently reserved your rights. It is very important that you understand just what this means. For example, one man used this in regard to a traffic ticket. When asked by the judge just what he meant by writing without prejudice U.C.C. 1-207 on his statement to the court, he had not tried to understand the concept involved. He only wanted to use it to get out of the ticket. He did not know what it meant. When the judge asked him, he told the judge that he meant that he was not prejudiced against anyone. The judge knew that the man had no idea what it meant because his statement was wrong, and he lost his case. You must know what it means. And I tell people that all the time, how important it is for you to understand what it stands for. Without prejudice, U.C.C. 1-207. When you use this phrase in connection with your signature, you are saying to the government, Ralph or Emerson, Mr. Freeman recommends that we must memorize this. I reserve my right not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, and intentionally. And furthermore, I do not accept the liability of the compelled benefit of any unrevealed contract of commercial agreement. That's what it means. And you can repeat that. It takes time to learn it. I understand that, but that's why I'm putting it here for you or explaining it to you. What is the compelled performance of an unrevealed commercial agreement? Question. When you use Federal Reserve notes instead of silver dollars, is it voluntarily? Question. No, there is no lawful money. So you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts with limited liability, and you don't have to pay your debts. But if you do not reserve your rights under this section of the U.C.C. 1-207, you are compelled to accept the benefits and are therefore obligated to obey every statute, ordinance, and regulation of the government at all levels of government, federal, state, and local. If you understand this, you will be able to explain it to the judge when he asks, and he will ask. So be prepared to explain it to the court. You will also need to understand U.C.C. 1-103, the argument and the recourse. If you want to understand this fully, may I suggest that you go to a law library and photocopy these two sections from the U.C.C. It is important to get the Anderson edition. Some of the law libraries will only have the West Publishing version, and it is very difficult to understand. The Anderson copy is broken down with decimals in 10 parts, and most importantly, it is written in plain English. Now, I hope you all understand it. That's how you go and research this stuff. And I know that in some cities, like for instance, my uncle is from the Chicago area, and you know, they took it out, the books, and he asked them, well, where are they? He said, so somebody took them. Yeah, I bet. So it's a lot of conspiracy going on there. They don't want people to be reading this and understanding it and its application. Recourse. The recourse appears in the U.C.C. 1-103 at 1-103.6, which says, the code is complementary to the common law which remains in force except where displaced by the code. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. This is the argument we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have to admit that the United States is bankrupt and is completely owned by its creditors. But it is not expedient to admit this, so the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1-207, you may then insist that the statutes be construed in harmony with the common law. If the charge in court is a violation of a traffic ordinance, you may demand that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with the failure to buckle your seatbelt, you may ask the court who was injured as a result of your failure to buckle up, or a failure of me to buckle up. However, if the judge won't listen to you and just moves ahead with the case, then you want to read to him the last sentence of 1-103.6, which states, the code cannot be read to preclude a common law action, ampersand, defined as to mean ignore, meaning not allow. Tell the judge, Your Honor, I can sue you under the common law for violating my rights under the U.C.C. I have a remedy under the U.C.C. to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. To be in harmony with the common law, you must come forth with the damaged party. If the judge insists on proceeding in the case, just act confused and ask this question. Let me see if I understand, Your Honor. Has this court made a legal determination that sections 1-207 and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers yes, then say, or then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so once again you have boxed him into a corner. See that? But I have to say, following this now, with so many people figuring out and using it and whatever, they're slamming you in the courts. I've been there and done it and see what they're trying to do. Because they're being bombarded. This is, this information is coming out. I know other people on YouTube are, reading the same stuff, and it's getting around, which is good. But we got to keep the pressure on these courts and on the government. And there's a lot of people too who use this, I've told, and they use it and then they think that it just automatically gets dismissed. No, I mean, it's supposed to, and it'd be great, but they know that people are just using it without, like I read the example about the man saying without prejudice just means I'm not prejudiced against anyone. They don't get the understanding of what it means. You got to understand the meaning, because you're going to have to explain it to the court. And once they know, they still may not let it go or whatever. But there's a lot of things that they do here with the trickery of this. They try to intimidate you. They try to do everything in the courtroom, to frustrate you. And typically what I found is you lose always in the first round or two, because they're trying to make you give up. And so therefore you have to go and appeal and this and that, and then finally it gets to the point where you're just like, hey, whatever, it's just like, geez. And I've been there, or I'm there. That's what happened in my last case. They got me on a technicality, because I was told one thing by the court, and then I was told another thing by this court, and they just, they won't hear the case because I got wrong information from the previous court of when my filing date was, and they said in the Court of Appeals that I had passed that date, and so this is the kind of tactics and game. I shouldn't even be there to start with, because I did everything in a timely manner, and it was read in court and everything, but that's the way that they're playing the game. They're playing hard because they realize what's at stake. Think about it. I've said it before. They don't want their slaves to escape. How much money this is dealing with. So it's a war. This is a war going on that people have no idea. And I'm telling you, they're going to have to do something quick to squash this, or try to, with some type of new terrorist attack or some new law. You can't do this or that, or some, and with all this stuff going on with the police stuff and the rioting and the cities and so forth, martial law. And get into all that in here. FEMA and the martial law and them declaring that, and then everything goes out. Everything is under Admiralty, Maritime Jurisdiction, martial law. So anyway, another little part I wanted to get into and explain to you is deep. It's another part of law that you have to understand, and this is long too, but I'm just going to try to cut it to you, just say it like this to you. All laws don't apply to us. What you may think is law is not, because there has to be enacted public law or positive law. They go together. And then there's private law and special law, which are not actual law. So let me read this to you briefly, because this is a very important part that I'm adding in here, that when I went looking over all of my stuff and all my books and papers and things like that I've had over the years. Listen to this. Public law is a law or statute that applies to the people, generally of the nation or state adopting or enacting it, denominated a public law, and contradistinguished from private law, affecting only an individual or a small number of persons. Black's Law Dictionary, 6th edition. The court refers to public law as positive law and is defined as positive law, law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. Black's Law Dictionary, 6th edition. An example of the foundation which I have presented above is expressed by the California Supreme Court when it stated, taxing and licensing statutes are not enacted as positive law, which consists of those statutes enacted by legislative bodies in pursuant to authority or mandate granted in United States or California constitutions. Such tax and licensing statutes are private, equity maritime law contracts which are entered voluntarily by private persons with the private corporate state. Escovedo versus State of California, 35 CAL .2D 870. Emphasis added. The above two paragraphs show the application of positive or public law and how it affects different objects or subjects. The ensuing paragraphs shall explore the meaning and application of private or special law. Private law, that portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations as used in contradistinction to public law. Black's Law Dictionary, 6th edition. Special law, one relating to particular persons or things or made for individual cases or for particular places or districts. One operating under a selected class rather than the public generally. A private law, a law is special when it is different from others of the same general kind or designed for a particular purpose or limited in range or confined to a prescribed field of action or operation. A special law relates to either particular persons, places, or things which, though not particularized, are separated by any method of selected from the whole class to which the law might, but not such legislation, be applied. Black's Law Dictionary, 6th edition. The California Supreme Court has applied these definitions to their practicality, to the practical sense in the following declaration. A general or public act affects the whole community, whereas a private act affects only particular persons or private concerns. Ex parte Burt, 59 CAL 6, a selected class or particular object. Earl versus Board of Education, 55 CAL 489, and Smith versus McDermott, 93 California CAL 421. And just this last part here, because this is really deep. The above paragraphs establish an insight into the type of law, confirming that their respective objects or subjects are not the same. Now we must consider how they are being applied to us in their administration. It is in the administration of these private or special laws that we average individuals experience limitations which impacts his freedom. When governmental agencies attempt to enforce these laws, they are proceeding under the presumption that each and every individual is the proper subject or object of the law. Under administrative law, the agency is permitted to proceed under these presumptions. Remember, in law, all presumptions are rebuttable. Excuse me, jeez. If an individual is ignorant of the fact that he is not the proper object or subject of that law, he will acquiesce to it because of his fear of punishment. It is this appearance of law or color of law which allows the honest law-abiding citizen to be brought under the control of laws that do not apply to him. The United States Supreme Court recognizes this reprehensible state of affairs when it declared, because of what appears to be a lawful command on the surface, many citizens, because of their respect for what only appears to be law, are cunningly coerced into waiving their rights due to ignorance. United States versus Milker, 350 U.S. 179 at 187. Do you understand that? This is what I'm talking about. This type of coercion, misrepresentation, and flat out deceivery, lies that our government is partaking. There's much more, but I just don't want to keep on with all of it. I want you to understand the importance of what I'm trying to tell you so far in these 4 parts of how this all comes together. Now, I think I've covered everything on that I need to cover. So I'm going to go ahead and go to part 5. The income tax hoax. So stay tuned with me on that, and see you then. Hi guys, back for part 5, the income tax hoax. This part will be the most, or usually is the most emotionally charged subject in America. When people start talking about it, things get heated and emotional. And I think it's because the fact is that it's dealing directly with your money. Let me say this. I don't understand the attacks on people like Wesley Snipes. I know Willie Nelson's gone through it. Many people have gone through it. The horrible way they did the heavyweight champion of the world, Joe Louis, back in the day. I just remember, and I talk about this, I have it on my YouTube channel, on one of those, on one of my videos about Wesley Snipes, and just the comments, you know, let's see you fight your way out of this one, Blade. When he was convicted on like 3 counts, he had beat most of them. I just don't understand it, because it's like, so why are people so hateful and spiteful about other people being put in jail illegally or whatever for tax, quote unquote? They call it tax evasion, or I don't get it. There is no law that you have to pay taxes, and I'm going to show it to you and prove it to you. Whether you accept that or not, it's up to you. But that's what it is. I just don't get it. Why people are so mean. And what's your point and purpose? I just recently came under attack, and when I read this stuff and stuff I get from people, it's always anonymous, or maybe they're using a fake name. I use my real name. I am who I am. I'm not hiding from anyone, because I don't fear any man or woman. You know, it's like this person, not to get into it, just recently attacked me about the whole U.C.C. code and this and that, and I had to show the person what it actually says and how it applies, and just the bottom line it comes down to, so what's your point? What's your attack on me for? What are you trying to prove? What is it that you feel that I'm such a horrible person that I'm trying to liberate, educate the American people on how they've been lied to and tricked into economic slavery or contractual slavery? What's your point of your attack? Are you for sovereignty and for the freedom of all people, or are you for the enslavement and control of all people? There's no one little bit or nothing. You're either pregnant or you're not. I don't get it. So anyway, I had to put that question out to that person and just come out bottom line. So what's your point? What is it that you want to say? You're accusing me of all this. Now I'm defending myself and explaining to you the law and how it's to be applied according to the law, or to, you know, the statutes or what have you. And your rebuttal was weak. And I've never heard back from you once I told you that. So what's your point? Who are you for? The people or the Illuminati? You're on one or the other side. You can't be on both. So anyway, if you want, if you're watching this video, hit me up on that. I'm very curious to know. Let me get into this. First of all, let me state this. I believe in paying any lawful and constitutionally imposed taxes to support our nation. I believe that labor is the most sacred property of a free people and cannot be taxed. To quote the courts, and I do have this case, but I forget where it is, the exact case, but anyway, to quote the courts, they said, the individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and chartered powers to the state. The individual's rights to live and own property are natural rights, for the enjoyment of which an excise cannot be imposed. Income tax is voluntary. Income legally refers to privileged activities and not to compensation for your labor. You must understand this, people. It's crucial. I'm going to read to you some of this. I didn't really want to have to read much to you, but I got to. I have no choice because you have to hear what I'm saying or what is being said, not my writings, but to put it all into perspective. The IRS has no external jurisdiction within the 50 states. The IRS is limited by the Constitution solely to the 63 square miles of the District of Columbia and federal possessions such as Guam, Puerto Rico, the American Samoa, the U.S. Virgin Islands, etc. There's a couple more. The term United States has 3 legal meanings, and that by law, one of the 3 entities called the United States is a foreign country to the 50 states united. And that although the people of the states have given this municipal corporation limited jurisdiction over their states, it has no paramount legal jurisdiction over the individual citizens of the 50 states, except by individual voluntary application and contract. Our labor is our property and a natural, unalienable right, as has been clearly established in the courts. In the case of Butchers Union Company versus Crescent City, the court said this: the property which every man has is his own labor, as it is the original foundation of all other property. So it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing this strength and dexterity in what manner he thinks proper without injury to his neighbor is a plain violation of the most sacred property. If the government is allowed to place a tax on a natural right, it can then raise that tax to the point where that right is effectively been destroyed. That is tyranny. The IRS collects taxes on income, and the Senate has been empowered to collect a tax on incomes from whatever source derived by the so-called 16th Amendment. But it has nothing to do with your wages. People who work for a living are compensated in the form of wages. Wages are non-income. They are compensation for labor, which the courts have affirmed is property protected as a natural right. Income is an accounting profit or gain that can be derived from investing your wages. But don't expect the IRS to point this out to you. For a legal opinion, it is always your best bet to quote court cases, preferably U.S. Supreme Court cases. Why? Because that's the highest court of the land. In the case of Oliver versus Halstead, 1955, the court ruled that there is a clear distinction between profit and wages or compensation for labor. Compensation for labor cannot be regarded as a profit within the meaning of the law. The word profit as ordinarily used means the gain made upon a business or investment, a different thing altogether for mere compensation for labor. The 16th Amendment does not authorize a direct tax on the wages of individual, but an excise or indirect tax on income derived from certain privileged activities, like the limited liability enjoyed by corporations. Between the years of 1913 and 1915, fewer than 2 million Americans volunteered to file income tax returns. Back then, they knew it was a tax only on corporations and certain licensed professions. The next income tax the American people were asked to volunteer for was the withholding or victory tax levied during World War II. The central banks, with a lot of help from the Congress, who they bought out and pay to this day to keep the American people ignorant on subjects like this, used the patriotism of the American people to further enslave them. And of course, the victory tax was not allowed to die natural death after World War II. So by 1946, the bankers had their hands deep in the American people's pocket of individual Americans by withholding directly from their paychecks, using the war as a pretext. Despite this, it should be understood that no matter what statutes, codes, or regulations the federal government creates, it has by law no authority to impose a direct tax on individual Americans unless we give it individual permission by some color of contract, or if we are under some form of martial law, which is what they're going to be doing next. The money interests knew this and have engineered the federal income tax system based on voluntary compliance. Do you get it now? I'm so sick and tired over these last 20 years hearing the ignorance of the American people, or many of the American people, on this subject. Did that just clear up basically everything for you? Do you get it now? And I'm not being condescending to you. I'm just very sick of this and tired of the ignorance of us all. It's time to wake up. And as I'm ending my workshop and getting close to the end, I've got to be thorough and I've got to be hard. Because this BS has got to stop. These criminal judges, lawyers, politicians, and so forth are driving me nuts. And you're believing everything that they're telling you when they're sitting there lying to you to your face. Don't put me in your drama and in your BS. Not going to play your game anymore. This is my message to you, the Illuminati. Let me finish this up. So what did they do? They engineered the income tax bullcrap around the 13th Amendment, which says in Section 1, neither slavery nor involuntary servitude except as a punishment, for crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. So what did they do? These people who are not dummies by any means, they're very intellectual in certain aspects. They engineered the income tax around another type of slavery called voluntary servitude. Economic slavery. Voluntary servitude is an ancient and established concept. It was the way serfs became subject to their lords during feudal times in England and other European countries. It was a way for free men to earn a living at the time when property was held by a select few, and thus anyone who wanted to farm and support their families had to first agree to be subject to the lord of the land. The forefathers hated this concept and designed the Constitution to exclude titles of nobility, making all Americans sovereign, but sovereigns without subjects, that is to say, equals among equals, peers at law. The fraudulent 14th Amendment turned the intent of the founders on its ear by making voluntary servitude a requirement for former black slaves to gain any of the rights already guaranteed to free-born state citizens. Not convinced yet? Still you don't believe it? Can't be. The government would never lie to me. Never. No. In their own publications. Not mine. Not Kev's. IRS. Let me give you two things. First of all, I have seen the book. I regret not buying it when I had the chance. Regardless, here's what it says. Here's two more evidence of things in the IRS. On the cover of the IRS Confidential Handbook for Special Agents, it read or reads, "Agents, our tax system is based on individual self-assessment and voluntary compliance. The material contained in this handbook is confidential in character. It must not, under any circumstances, be made available for persons outside this service." Why the secrecy? If it's a law, we are supposed to follow the law. Why is all this confidential secrecy? Because it's a fraud. The IRS 1993 1040 Easy Form, an instruction booklet in which Margaret Milner Richardson, who was at that time the IRS commissioner, stated on page 3, "Dear taxpayer, thank you for making this nation's tax system the most effective system of voluntary compliance in the world." There it is. I didn't make it. The next year, 1994, 1040 Easy Book. Oh, they didn't say that this time. They took it out. Oh, Margaret said, "We got so many complaints and people started saying, 'What's going on here?' We can't write that anymore." Wake up. Wake up. You ready for more? I got more. I got lots more. Got so much, it's just unbelievable. I ain't even gonna read that. I was. No point. This is an interesting thing. USA Today, Friday, July 7th, 2015, almost 15 years ago. This was the original paper. You can go look it up. We the people. You know who that is, right? I taught you that, right? This was a remonstrance of the tax thing. I'll just read a little bit of it because it's a lot, but I'm just trying to figure out what part to read to you. Most citizens are not required to file an income tax return. The 16th Amendment income tax to the Constitution is a fraud. If you file, you waive your Fifth Amendment rights. Okay, I'm just going to read part of this to you. You can go look it up. Go do research. I do it, and I spent many hours, months, and years doing it. You need to do it too. That's how you educate yourself. I'm going to read this, okay. These are the major points expressed in a remonstrance that was hand-delivered to leaders of the three branches of the federal government on April 13, 2000 by a group of citizen delegates representing all 50 states. These grievances concerns alleged illegal operation of the federal income tax system and the IRS. The remonstrance was signed by thousands of citizens and was delivered as part of an event sponsored by We the People Foundation for Constitutional Education, a non-for-profit corporation dedicated to research and education in matters of taxation and governance. Right off, let me say this to you. Or let me read this. The main propositions of the remonstrance are: the 16th Amendment to the U.S. Constitution, the Income Tax Amendment, was fraudulently and illegally proclaimed to be ratified in 1913. Exhaustive legal research from both state and national archives document conclusively that the amendment did not even come close to being legally approved by the required number of states. The courts have refused to hear this issue. Defendant, I'm not sure if I'm pronouncing the name right, but Stala, S-T-A-H-L. Stala's claim that ratification of the 16th Amendment was fraudulently certified constitutes a political question because we could not undertake independent resolution of this issue without expressing lack of respect due coordinate branches of government. U.S. versus Stala, 1986, 792, F2D, 1438. See? Take this stuff to the courts, and they say, well, it's a political question or issue. No, it's a fraud issue. Fraud. Because two gentlemen, patriots by the name of Red Beckman and Bill Benson, spent 2 years of their life going to every single state in the United States of America to look up at that time the ratification of the 16th Amendment. What did they find? As you just heard, it didn't even come close to the required 3/4 of the state's approval. Philander Chase Knox was a fraud. The state attorney, or whatever his position was, lied and said that it was ratified, when in fact it wasn't. And the courts refused to hear this issue? And the American people aren't up in arms over this? This is what we're talking about. They've tried, and other people have tried, to sit down with this ridiculous government to talk about this. And like I told you, this is an emotion-charged subject because I've had to spend so many of my years in this BS fighting these stupid, idiot, Masonic, controlled government people. And I'm tired of it. When they tried to sit down with the government agreed to sit down and to talk to the American people about the legality of the income tax. Do you want to hear what they said? Do you? Listen to this. And this is long after they agreed that they were going to do this. However, on June 2nd, the White House reneged on the promises it made during the April 13th meeting. As with 3 previous conferences, the government has again refused to debate the grievances. Jason Furman told Robert Schultz, "The legality of the income tax is not a high priority item at the White House, and we will not participate in any conference on the subject. We have reached the point where the government evasion must be regarded as an omission." Thank you very much. I'm not even going to do it anymore right now. I was, but just you hearing that should be enough to make you sit there and say to yourself, it's time. I was going to read some more stuff, but you know what? There ain't no point. Because if you don't get it by now, you're not going to get it. Howard Freeman, back to the U.C.C. code. Stated this to the person who attacked me on this. Another myth here, right? Using the code with the IRS. If the IRS sends you a notice of deficiency, this is called a presentment. In the U.C.C., a presentment in the Uniform Commercial Code is very similar to the common law. But first, we must understand just how this works in the common law. Suppose I get a man's name from a phone book, someone I have never met, and I send him a bill or invoice on a nice letterhead which says, "For services rendered, $10,000. I send this by certified mail to him at the address taken from the phone book. The man has to sign for it before he can open it, so I get a receipt that he received it. When he opens it, he finds an invoice for $10,000 and the following statement. If you have any questions concerning this bill or the services rendered, you have 30 days to make your questions or objections known." Of course, he has never heard of me, so he just throws the bill away and assumes that I am confused or crazy. At the end of 30 days, I go to court and get a default judgment against him. He received a bill for $10,000, was given 30 days to respond. He failed to object to it or ask any questions about it. Now, he has defaulted on the bill and I can lawfully collect $10,000. That's common law. The U.C.C. works on the same principle. The minute you get a notice of deficiency from the IRS, in anyone else state, you return it immediately with a letter that says, "This presentment above is dishonored. Kevin Perteete," your name, "has reserved all of his rights," or her, of course, if you're a female, "under the Uniform Commercial Code at U.C.C. 1-207. I've already told you that's been changed. This should be all that is necessary, as there is nothing more they can do. In fact, I recently helped someone in Arizona who received a notice of deficiency. The man sent a letter such as this, dishonoring the presentment. The IRS wrote back that they could not make a determination at that office, but were turning it over to the collections department. A letter was attached from the collections department which said they were sorry for the inconvenience they had caused him, and the notice of deficiency has been withdrawn. So you can see that if it's handled properly, these things are easily resolved. Why do you think the government, the IRS, goes after rich people or famous people a lot? Some people say because they got the money. They got all the money. They're not worried about us. The hell they're not. They come out to small people just as much. You just don't hear about it on the news. It's a scare tactic to scare you. If they're coming after Wesley Snipes, he's worth millions. What are they going to do to me? They're coming after him. He's Leona Helmsley. She's worth billions. What are they going to do to little poor old me? They do that to scare you into paying something that you have no legalities on paying. When the IRS loses big cases or small cases or any case, do you hear about it? No. Why? Does your local news say, hey, the IRS got their butts beat today. We're happy to report something good for the people for a change. Why do you think that is, folks? Why do you think that is? I'm going to read to you this because I want you to hear this because it makes me so proud to this day. It wasn't a U.S. Supreme Court case. It wasn't a huge court case. And like I said, a lot of my information, I won't say it's older or, you know, by no means I want to say outdated. But there may be some newer cases, better cases now that have gone. Like I said, I've been out of this for a while, but it's enough, I believe, it's still very, very important information and valid information. So remember something, because I've had these fools in court. Well, Mr. Perteete is quoting a court case from 80 years ago. Well, the court case is still valid. It doesn't matter. It's still valid. What difference does it make if it was last year, 5 years ago, 50, 80, 100 years ago? If it was never overturned or overruled, it's still a valid case. Anyway, this was a case in Tennessee. IRS loses big case in Tennessee back in '93. Bet you didn't hear about it. A not guilty verdict came in the Eastern District of Tennessee in the case of U.S. versus Lloyd R. Long, CR 1-93-91. The verdict came on October 15, 1993. This was an amazing case involving the income tax. A Chattanooga jury agreed with the argument by Long that the income tax is actually an excise tax and only applies to certain classes of people. Nationally, prominent attorney Lowell Beecraft in Huntsville, Alabama, assisted by attorney Russell J. Leonard of Sewanee, Tennessee, defended Lloyd R. Long of Decherd, Tennessee. Long was charged with willful failure to file income tax returns for 1989 and 1990. In presenting the case for the IRS, the government represented by Assistant U.S. Attorney Curtis Collier, assisted by Special Agent Michael Greasley of the IRS, declared that Long had grossed income in excess of $49,000 for each year, and that he willfully failed to file income tax returns. The defense admitted that Long had an income in excess of $49,000 for each year in question and that he did not file a return. He then proceeded to to prove to the jury beyond a reasonable doubt that he was not liable for an income tax, nor was he required by law to file. Defense testimony showed a case titled Broshaber versus Union Pacific Railroad, wherein it was the unanimous decision of the U.S. Supreme Court that the 16th Amendment did not give Congress any new power to tax any new subjects. It merely tried to simplify the way in which the tax was imposed. It also showed that the income tax was in fact an excise tax on corporate privileges and privileged occupations. The defense then brought out a case entitled Flint versus Stone Tracy, wherein an excise tax was defined as a tax being laid upon the manufacture, sale, and consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. Mr. Long's attorneys also brought out a case entitled Simmons versus Ahrens, A-R-E-H-N-S, I'm not sure how to pronounce it, wherein the court ruled that the income tax was neither a property tax nor a tax upon occupation of common right, but was an excise tax. The defense then brought out a case entitled Redfield versus Fisher, wherein the court ruled that the individual, unlike the corporation, could not be taxed for the mere privilege of existing, but that the individual's right to live and own property was a natural right upon which an excise cannot be imposed. Defense also pointed to a couple of studies done by Congressional Research Services that shows the income tax is an excise. Next, defense pointed out that in Tennessee Supreme Court case Jack Cole versus Commissioner, the court ruled that citizens are entitled by right to income or earnings, and that right could not be taxed as a privilege. In another Tennessee Supreme Court case, Korn versus Fort, the court ruled that individuals have the right to combine their activities as partnerships, and that this is a natural right independent of antecedent of government. The prosecution did not challenge or attempt to refute any of these cases cited or the conclusion of the courts. Defense brought out in testimony the fact that nowhere in the entire Internal Revenue Service Code was anyone actually made liable for the income tax. They showed that in the IRS own Privacy Act notice, only 3 sections were cited, and that none of these sections made anyone liable for the tax. They also proved that this was not an oversight by showing that the alcohol tax was worded so clearly that no one could misinterpret who was liable for the alcohol tax. Prosecution did not challenge or attempt to refute this point, nor were they able to show a statute that made anyone liable for the income tax. Defense then presented the mission statement on the IRS stating that the income tax relied upon voluntary compliance, and a statement from the head of the Alcohol and Tobacco Tax Division of the IRS, which in essence showed that the income tax was 100% voluntary, as opposed to the alcohol tax, which is 100% mandatory. Mr. Long stated that in 1989 he knew that the income tax was in fact an excise tax, and that he was not enjoying any corporation, and that income or earnings from the exercise of common right could not be taxed as an excise or otherwise, and that nowhere in the IRS code was he made liable for the tax, and that the income tax was voluntary. Long then stated he was so intimidated by the IRS that he filed and paid his voluntary assessment. He then began a series of letters to the IRS explaining that he had no license or privileges issued to him by the federal government. He asked for direct answers to simple questions such as, am I required to file federal income tax returns? And am I liable for federal income taxes? The IRS never gave a direct answer to any questions. Instead, they inferred and insinuated and extrapolated and beat around the bush and generally avoided answering. So Mr. Long testified that he decided to stop volunteering. The IRS brought in 2 expert witnesses. Both were actually IRS employees who had received training as professional witnesses. Upon cross-examination by Attorney Beecraft, one witness, a Miss, I think it's pronounced J-E-U, I don't know, J-E-U, stated that a secret code known only to IRS and encoded on Mr. Long's permanent record showed that the IRS knew that he was not required to mail or file a return. Mrs. Gia made every effort to avoid this admission to the point that she was beginning to frustrate the jury. The other witnesses, upon cross-examination by Beecraft, gave testimony that conflicted with the Privacy Act notice. The government also attempted to institute guilt by association in that they claimed Mr. Long had known and relied upon persons of questionable character. They argued that the writers of some of the books he read and people he knew had been convicted of tax-related charges in the past and were in fact criminals. Long responded that just because a person has been convicted of a crime by a court did not invalidate everything said. To illustrate his point, he pointed out the Apostle Paul was a murderer, but that by the grace of God he became the greatest of the apostles. Mr. Long added that he did not rely on anything that he did not personally check out thoroughly. In summation, attorney Larry Beecraft reminded them that Galileo was imprisoned for holding a belief that conflicted with one which everyone else knew as fact, and that Columbus acting on a belief which conflicted with what everyone else knew as fact, discovering something no one else thought existed. Now I have my things about that stuff there, Columbus and all that, but I understand what they're saying. The jury agreed with the defense by finding Mr. Long not guilty. On all counts, they have ventured into history as preservers of freedom. A Chattanooga TV station quoted a government spokesman as saying that this case will change the way the IRS will handle such cases in the future. They indicated that they will be less likely to prosecute if a jury isn't going to decide in their favor. Excuse me. Mr. Long's spirit was best expressed when he was asked for a final statement by a reporter and as he was leaving the courtroom. His words, "To God be the glory. Congratulations, Lloyd." I hope that pretty much ends everything I need to talk to you about the income tax. And I'm just going to show you a little bit more and I'm done. Excuse me. This happens every time I talk. Supreme Court cases. I'm not going to read them all, it's a lot. You can go look it up. The internet is one of the greatest inventions in the history of the world, in the fact that you have a library, encyclopedia, everything at your hands. I understand that everything on the internet is not true or correct, whatever. I got all that, but for the most part, there's many things that you can do in the privacy of your home and researching and fighting for the freedom of all peoples around the world. Just showing you, these are all U.S. Supreme Court cases on taxes and the illegality of it. Okay, go look it up. This isn't my stuff. I didn't make it up. Sorry. I know some of you thought I was just talking crap and I don't research and look up cases. There's so many. This starts in 1818 with different things, but I'm not even going to read a lot of it. I mean, just I'm just going to give you a couple of them. Just as I'm looking over, I don't even have this in order in where I want to talk to you about it. Some of it's long. This is the summary. You know, things that were brought out in the case. 1930, Lucas versus Earl. The Supreme Court ruled that wages and compensation for personal services were not to be taxed in their entirety, but instead the gain or profit derived indirectly from them. You've heard that. Let me see. I found this kind of interesting. BOLLW, B-O-L-L-O-W versus Federal Reserve Bank of San Francisco. All persons in the United States are chargeable with knowledge of the statutes at large. It is well established that anyone who deals with the government assumes the risk that the agent acting in the government's behalf has exceeded the boundaries of his authority. Economy, Plumbing, and Heating versus U.S. Persons who are not taxpayers are not within the system and can obtain no benefit by following the procedures prescribed for taxpayers, such as the filing of claims for refund. So if you're not in the system, you're not a part of it. It doesn't apply to you. And I'll talk about that later. I'm sorry. I'm sorry to give dead air. I just wanted to read some of these short ones to you. Because some of these cases are very old, but like I said, they still apply. Adams versus New York. The court said that the Fourth Amendment was intended to secure the citizens in person and property against unlawful invasion of the sanctity of his home by officers of the law acting under legislative or judicial sanctions. This protection is equally extended to the action of the government and officers of the law acting under it. Let's see here. Some of these. One of the famous cases back in 1895 was Pollock versus Farmers Loan and Trust Company. And it says, prohibits direct taxes on the incomes of individuals. In that case, that was a very famous case that income tax was declared unconstitutional. So that's a real big, important case to read. Now, let me just go into some of this. For time's sake. Flint 1911 case, Flint versus Stone Tracy Company. defined excise taxes as taxes laid upon corporations and corporate privileges not in natural persons. Excise are taxes laid upon the manufacture, sale, or consumption of commodities within the country upon license to pursue certain occupations upon corporate privileges. The requirement to pay such taxes involve the exercise of privileges and the element of absolute and unavoidable demand and lacking conceding the power of Congress to tax the business activities of private corporations. I already read to you part of that earlier, but I wanted to make a point on a few of these cases that I personally have went and sat in the law library and looked it up. Because a lot of people sit there and try to tell me, oh, well, you know, here's the case. Here it is. Go look at it for yourself. Go research. I did it. Took me a long time to copy that. It's a really thick booklet of cases. That case. Flint versus Stone Tracy. Here it is in its entirety. Next case that I went and looked up was Brosheber versus Union Pacific Railroad, which was 1916. Here it is. It's a whole case. What was the highlight of that? There's a lot to read, but I'm not going to read it all to you. It established that the 16th Amendment had no effect on the Constitution and that income taxes could only be sustained as excise taxes and not as direct taxes. It goes into a lengthy thing. I'm not going to read it all, but it's here. Go spend some time in the law library. It's free. I mean, you got to pay, you know, to copy that stuff. And here's another one, the last one I'm going to show you that I personally looked up. It's here. It was all in here. I did this years before I found this. This is some new stuff I found kind of on the internet. 1959 case, Flora versus United States, 362 U.S. 145. Rule that our tax system is based on voluntary assessment and payment, not on force or coercion. Our system of taxation is based upon voluntary assessment and payment, not upon distraint. People, research, learn, get in there. Don't be afraid. It's there. I want to show you something. And it's just not that hard in that regard. Like I already told you, I hate this stuff personally. Where is it? Or was it this one that I did? I want to show you something in one of these cases. I thought that was it, but I guess it wasn't. It's important to me. I think that was it. Yeah, that was it. I'm missing. I hate eating up airtime like this. So anyway, I'm about to close this out. This is really disturbing to me because I just highlighted it recently, and I know it's in here. So I don't know where it went. I should have had it ready. Oh my gosh, this is weird. Oh, here it is. All right, jeez. Just so you know, this is. So people say, well, that didn't say that in that court case. Here it is. It's in the court case. I found it, okay? It's in there. What? The exact statement of the highlight of the case. Our system of taxation is based upon voluntary assessment and payment, not upon distraint. It's there, guys. It's in these cases. Get out there, research, and look into it. Let me say this to you in the last part of this, and I'm done. And we're going to go into part 6. Let me say this to you. No crimes for individual. This is something about the taxing and understanding something, because it's very important. Because people always ask the question, how come you're thrown in jail? How come this? How come that? Let me read why. Since certain individuals are not subject to an income excise tax, they cannot lawfully, they cannot lawfully to be subjected. I think there was a misprint here. Let me start over. Since certain individuals are not subject to an income excise tax, they cannot lawfully be subjected to tax-related criminal penalties. All the criminal penalties in the Internal Revenue Codes are contained in Chapter 75, Section 7343 of that chapter. Defines a person who is subject to criminal penalties. An individual is not listed as being a person subject to criminal penalties for failure to file a return, failure to pay income tax, or any other tax law violation. Section 7343 states, the term person as used in this chapter includes an officer or employee of a corporation. And I've already given you the definitions of that employee stuff, all right? And or employee and individual and all that. Or a member or employee of a partnership who as such officer, employee, or member is under a duty to perform the act in respect of which the violation occurs. Only those people who are required to act on behalf of a corporation or partnership are listed as being a person subject to criminal penalties. If an individual is not in that capacity, he is not required to act, and he cannot lawfully be subjected to any criminal penalties under the code. I'm about to run out of time, so I wanna read these other parts to you because it's very important. Now you might ask how citizens are trapped. If these statements are true, how are individuals sent to jail for Internal Revenue Code violations? Sadly, most are convicted by their peers, fellow individuals who do not understand the law. Prosecutors and judges do not discuss long-standing Supreme Court decisions, and jurors generally are not cognizant of the constitutional limitations regarding or relating to taxation, so they frequently vote guilty in tax cases where no crime has actually been committed. If one is not subject to the income excise tax, he or she is not committing a crime by not filing a return or by not paying the tax. People should remember the following important facts. When an individual files an income tax return, he establishes liability to the tax by his own actions of filing a return and voluntarily assessing himself. The voluntary action of filing is considered to be acknowledgement that he is required to file as a taxpayer and that he is therefore subject to the tax. Anyone who admits to being a taxpayer is caught in the trap-like definition of the word code in section 7701A14. The term taxpayer means any person subject to an internal revenue tax. What can we do? The U.S. Constitution is the supreme law of the land. It was written to create a government of limited powers for the primary purpose of securing citizens' rights to life, liberty, and property. The Declaration of Independence states that it is the duty of citizens to oppose and resist abuse of their rights. These violations of citizens' rights can be stopped if enough people become informed of these facts. Show this information to your friends. Copy the articles. Talk to news companies or news, the news. Try to get the media informed. Call your radio talk shows. The American people must be informed of these facts so that they can take action to restore and preserve their rights. Your labor is your property. Knowledge will give you the power to protect and enjoy all the fruits of your labor. That's about it because it's about to run out. Stay tuned for part 6. That's where I'm going to discuss and teach you and show you how to exempt yourself from taxes from your job and all of that information. I haven't even titled it yet, so whatever it is, but it will be the last part. Thank you. Alright guys, welcome back for the last part, part 6, which I've entitled Exempt Yourself from Taxes Coming Out of Your Paycheck. Now, first of all, I would like to give a shout out to some people who have sacrificed and who have been imprisoned put in prison over the whole tax issue. Joe Bannister, Sherry Peel Jackson, Irwin Schiff, the late Dixon McCann, who died in prison, Ed and Elaine Brown, and to all the many others out there who I don't know and I've missed. Those are some of the ones that have touched me personally in their case. Guess may God be with you, and in that sense, or thank you for your patriotism and for your sacrifice in, you know, what you've done to help educate the American people. So many of you don't realize the war or the battles going on in the area of taxes, and people fighting out there and dying and being imprisoned falsely, and it's a huge area. So just wanted to give them a quick shout out as we go into this whole tax thing, or as we've been in it, but you know, they're very important people in the movement. Real quick, I want to share with you, I got a ticket a day or two ago, you know, doing this video, what have you. I haven't gotten a ticket in a while. It's been over a year and a half, or about a year and a half. And of course I signed it, as you know, without prejudice, U.C.C. 1-3. You can't see it on there, but it's on there. And just a bit of knowledge I think I want to pass to you real quickly on this ticket. And it's this. I realize that these officers, when they pull you over and get a ticket, and you start talking about U.C.C., they don't know what the hell you're talking about. They have no idea. And, you know, maybe a few do, but for the most part, they don't know what you're talking about. And I think I've learned that when you get a ticket, you understand something, I get very angry, and I'm very outspoken, as people who know me know that I don't hold back. But I've learned, I think, to just, dealing with this type of stuff, just shut your mouth and just let them do what they're going to do and not rudely fight with them. The reason why I'm saying that is because I have the biggest trouble of all with that. Believe me. But I think I've learned, stay calm, you get pulled over. Whether you did or not, doesn't matter. Doesn't matter what it is. You use without prejudice U.C.C. 1-308. If you ran a red light, doesn't matter. As long as there was no injured party or you didn't damage some property or what have you, doesn't matter what you did. How apparent, minor or major it is, as long as I told you that there's no damage that was done. So what I'm saying to you is this. You get pulled over, typically you could say something like, you know, officer, you know, I operate under common law jurisdiction and common law right. Is there an injured party, or has a crime been committed? If not, am I free to go? You can still say it, but I think I've realized that there's no point, because remember something, when a cop pulls you over, you're not necessarily going to get a ticket. They may just give you a warning. And not that it's wrong to say that to them. You can, because that's your legal right. But if you infuriate the cop, or you start arguing with him, or have an attitude with him from the beginning, although he may have one with you, he's gonna give you a ticket. He's gonna be rude to you. You're gonna get into a heated, you know, argument and this and that. They may not write you a ticket. So just play it along and just don't argue with them. Just let them do their thing, and you can say it to them and just be like, officer, I'm not being rude to you or trying to, you know, disrespect you or anything. I'm just telling you that I operate under common law jurisdiction. And he may say, well, what's that? You know, the fight's going to be between you and the court. But like I said, he may not even give you a ticket. So if you're cool with them, you know, and believe me, it's hard for me to do, because sometimes they're very rude and they really piss me off for pulling me over, or not even pulling me over for something I didn't even do or whatever. But I think that's just a bit of wisdom to pass on in light of all of the stuff that's going on with people being shot and killed over being pulled over and stuff. How many times does that happen in, you know, in our country over the many years, you know, of officers pulling you over. Anyway, enough on that. Another area I want to talk to you real quick is on this, how people talk to me about the different taxes. Always when people hear, you know, you don't have to pay income taxes, legal, oh, you have to pay taxes, who's going to pay for the roads, who's going to pay for the mentally challenged or the disabled? You start, right when I hear people who, you know, talk like that, I realize and know that they have no idea what they're talking about. And understand, guys, I'm talking to you here on a specific area of taxes, and that is your labor or your wages, your paychecks. And there's different taxes for different things, okay? So don't get confused that because you don't pay taxes out of your paycheck that the roads aren't going to get paved, that people aren't going to be able to do this and that, this and that. That's not at all the case. There's taxes that cover those areas. That's what the gasoline tax is for. There's a federal gasoline tax in there for the roads and other taxes. So don't get confused on the different taxes that go on. There's, I don't even know how many, you know, dozens or hundreds of different taxes that go for different things. So learn and educate yourself on the subject first before you attack someone about a subject. Just words of wisdom. The next thing here, and just getting into this now because I don't want to take up any more time, this is what we do. First of all, to exempt yourself from payroll taxes out of your check, you want to do this. You're going to want to write a questions and mail it to the IRS return receipt. So then you have proof that they received it. What do I mean? You're going to write something like this to the IRS. Dear IRS, it has come to my attention that taxes are voluntary. I have been researching and studying and finding out that our tax system is based on voluntary compliance. When I work for a living, that is a common right, and that is not to be taxed, or that is not defined as income. I would like your input on the subject, you know, who or am I required to pay an income tax or labor tax? Or what is income tax? What is the law? Could you please send me the law that explains or shows that makes it mandatory for me to pay taxes? You can word it any way you want. There's many different formats of how you can do that. But you want to do that, mail it off, return receipt. Something like this. And that's not quite it, but I'll explain this to you in a second. What you're doing when you do that is you're setting them up and you're protecting yourself. Because see, you're going to need that, and give them approximately 60 days to respond. Because the government is busy, you know, 30 days is a little short, 45, but get 60 days, 2 months, and see if you get a response. You more than likely won't. And some of the people that have, there's been a good response. Like, at this time, we are not able to determine that you owe tax or whatever, you know, and they send you that. Anyone who gets a letter like that, please inform me or let me know that. I would love to hear what they say. Typically, they just won't respond to you, which is an admission of the fact that there is no law. And there isn't, regardless. But so do that. That's your insurance policy right there. Okay? Very important. On this is way back in the day. But I did it, and I never heard back from them for many, 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 many years. And I'm just going to read this to you. I unfortunately lost the actual letter that they, you know, sent me trying to tell me that requesting for my tax return. But I'm just going to read this to you very quickly. To whomever this may concern, in response to your notice dated 2/17/1997, request for your tax return, you have a misnomer and wrong address for the one you're looking for. If you're looking for Kevin Perteete, this is the sovereign address and name. Then you can locate him. Then the above location is how you can reach him. In your notice title, request for your tax return. Notice how they asked words like request, may, shall have no legal meaning in law. You can look it up. It doesn't say mandatory requirement of your tax return. See the words? Anyway, if you are referring to Kevin Perteete, what taxable activity or event has he been involved in that makes him subject to filing requirements? Also, could you please send to Kevin Perteete his master file and decoder book? Thank you. Sincerely. There's a master file that they say they have on everyone, and it's labeled very difficult, like you can't understand it, but there's a decoder book that they have, and you can ask them to send it to you. Nevertheless, I never got it, of course, but it was done, return, receipt, see? So that's what you have, because when you walk into that court, and see, what many people make a mistake is they just stop paying the tax first. No, don't do that. I mean, you can. You're just putting yourself in a more vulnerable situation. Because what you want to do, like I said, question them. And then if he goes to court, judge says to you, well, did you make contact with the IRS to ask them what the law was on the taxes, or explain to them that you felt that you have read the law and from what you've concluded, you're not subject? Did you even do that? And you say, well, no, Your Honor, I didn't. So, why? What is it that you want me to do? I mean, you just stop paying taxes. So you have to pay taxes. We all do. I do. So what would make you think you could just do that? But see, when you send that, and you say, well, yes, Your Honor, I sent the letter. I asked them. It has come to my attention that this is a voluntary compliance issue. I don't have to pay, court case such and such says it, and they never responded. Then the ball's on their court. Makes them look bad. Well, why didn't you guys respond to this? See? That's just your insurance policy. It may not necessarily go like that because the judge is in on it too, but it's just, as you see, to protect yourself. So it's very important for you to do that. And that's how you set them up. And you can do it for your state. Like there's a franchise tax board in California. Other states, I think Illinois, have it too. And you want to do the same thing for them also. Okay? Now, the agency that you would send that to, this is some old information. I mean, I don't know that they're even still around, but you want to send that to your IRS local office or address. You have to look that up for your area. But the main one is the Commissioner of Internal Revenue Service, 1111 Constitution Avenue, Northwest, Washington, D.C., 20224. That's the headquarters of the IRS. You can mail it to them too, and they'll get it. And that's kind of the short way to do it when you are sending it off to the IRS. But I have personal paperwork that I did many years ago, and the different agencies of the government, I hit them all pretty much. So I sent letters to the Commissioner of the IRS, Social Security Administration, the Federal Reserve Bank Incorporated, Department of Health and Human Services, Department of Commerce, Attorney General, Speaker of the House, and to the California State Franchise Tax Board. This is a little different paperwork. This is dealing with something else, my citizenship. I mean, it includes that stuff too. But anyway, that's just, some of all the places you can send that to. But if you want to just stop your taxes and get started on that, then just hit the IRS and your franchise tax board. Excuse me. The next thing I want to read to you is an explanation of your use of your Social Security number as a condition to work. As I already told you, you don't need one, or do not need one. I'm going to show that to you in a slide presentation with the different forms and things that you can use. But I want to read this to you so that you can understand it. To whomever this may concern. And this is just a letterhead that you would just give to your workplace. But you don't have to, because like I said, the other forms that I have are a little better. But to whomever this may concern, regarding the use of Social Security numbers as a condition to work. A citizen is not required by law to possess or use a Social Security number. The IRS cannot issue penalties against companies which fail to furnish a taxpayer's identification number or Social Security number for their workers when filing company returns. The code allows an omission for reasonable cause. A penalty will issue willful neglect to request such identifiers. A penalty is not normally assessed for de minimis failures. Following are some facts which should completely resolve this dilemma. There are 3 sections of the Internal Revenue Service Code which apply to the circumstances in question. They are 26 U.S.C. section 6109 A3, 26 U.S.C. section 6721 A2B, section 621C 1B, and 26 U.S.C. section 6724A. These passages came about for the most part as a result of the passage of Public Law 101-239 on December 19, 1989, the Omnibus Budget Restoration Act. The Internal Revenue Code sections referred to above support the policy that the company is merely to request the worker to provide the company with his Social Security number or TIN number. See section 6109A3. If the worker does not provide the number for any reason, regardless of what it is, the company must obtain from the worker a written explanation for inclusion with the company tax returns. If a penalty were to be imposed under section 6721A2B for that omission, that penalty would be unlawful and would constitute harassment. In the event the company submits a few returns with identifiers omitted, then section 6721C1B would apply. The penalty provided in section 6721A is a nominal $50 for an incomplete return, and that is considered to be a de minimis failure. Section 6721C, the de minimis doctrine, as defined in Black's Law, states, the law does not care for or take notice of very small or trifling matters. The law does not concern itself about trifles. The IRS would not normally go to the trouble of imposing penalties on a company which omitted a few identifiers when supported by worker statements. This would be a de minimis failure which would fall under section 6721C. In connection with requirement section 6721C1B, we must additionally consider section 6724A, which states that no penalty shall be imposed if it is shown that such failure is due to a reasonable cause and not for willful neglect. The probability of an assessment is remote. However, if a computer-generated automatic assessment is sent to the company, a simple letter of explanation would suffice. In that case, the company should state that the identifier was requested but not provided, and refer to the copy of the affidavit sent with the return. This procedure will be sufficient to waive any penalty pursuant to section 6724A. The employer needs only to furnish the information provided him by the worker and then pass it on to the IRS as described above. The provisions of the Internal Revenue Code only appears to require that which is actually voluntary. As you have read and seen, the provisions of the Internal Revenue Code noted above are that an affidavit would resolve the apparent conflict. In the event you would feel more comfortable about the matter, I agree to sign a hold harmless agreement with you. Such an agreement would state that I will assume personal responsibility for any penalties wrongly imposed upon you for failing to obtain a Social Security number. See me for the conditions to this agreement. See, all you do is something like that. But it's been cut down in the information I'm going to share with you on the slides with the different forms that you really don't have to do this. It depends on how hard you bump heads with that employer or workplace with them stopping the taxes. But I thought that was a good piece right there. And there's many different types of declarations and tax exempt status things that you can make up and do. But like I said, I have a really good one that I'm going to show to you in a moment. Just trying to think what else to explain to you on this, and understanding how it can go. Now, another area, and you want to do it cordially. You don't want to, be kind of too stern or hardcore with the people. I've done it because it just upsets me, once I learned and found out all this stuff that has been hidden from us and we've been lied to. I take a little harsh actions. But the bottom line is that if they do continue to take taxes out after you have given them the proper paperwork and you followed the procedures and the law that you are allowed, you can let them know and send in your own, another declaration to them and let them know. If you take or continue to take deductions or withholdings from my labor, paychecks, without my authorization, you are then subjecting me to a tax that I do not owe, and this is fraud. Legal actions may or will be taken against you, and you can cite, certain different codes or, laws that state that the stealing of one's property is considered a violation of law or whatever. So, like I said, it depends on how you want to take it and how hard you want to do this and so forth. There's something else I'm trying to remember. It's very important I wanted to kind of tell you on this. But anyway, I'll try to remember it and come back to it when I come back to you after you see the different forms, which I'm about to show you, dealing with the taxes and so forth. So stay tuned, and I'll be right back after a few minutes after you watch the different forms slide presentation. Okay?
Okay, the W-8 Certificate of Foreign Status is the form that you use as a sovereign state citizen to stop the taxes coming out on the federal level from your paychecks. You would check for broker transactions or barter exchange. This was the form that I used back in the day when I was a part of the state citizens. I don't know if there's an updated form. You would have to find that out if you go the route and you want to become a sovereign state citizen. I will give you that contact information at the conclusion of this lecture seminar. The person's name was at that time Richard McDonald. I don't know if he's still around or still does it, but that's the one half of the form. The next half is a non-resident withholding exemption certificate, which is called the 590 form, which is what you see here. And on that one, you would check off the certificate of residency. Now, don't mind and pay any attention to the years of the forms. These are very old. These have been in my possession for a long time. These were the forms that we used at that time to exempt ourselves from the taxes. You can get the updated forms, and I'm sure that if you become a part of the state citizens and you get the kit, they will give you the updated forms or even newer forms or something that they may use differently altogether these days. But they had a pretty good support group back in the day, and they would help you along with all the information, not just the taxes, but all parts of the state citizen kit. The next form is the I-9 Employment Eligibility Verification that you see here. And this is actually a form that I filled out recently applying for a job. And the main things I want you to see on that form is where it says, I attest on the penalty of perjury that I checked a citizen of the United States. Now, I don't know if you can see it clearly on here, but I crossed out or whited out the small c and put in a capital C. And then next to it, I wrote in parentheses, in its original intent and meaning written in the Constitution for the United States of America 1787, to let them know that I am speaking of me as the sovereign, not the federal 14th Amendment U.S. citizen slave. So I do that personally on paperwork where I can do it and correct it, because it's very important for me to let them know that that's the meaning and the intent when I sign that paperwork, and not tricking me into some other class of citizenship or into the tax system. That's my personal way of doing it. The next thing I want to share with you is the best forms that I have found to date, and this is what I currently use. It's in two parts. First is the notice which I am going to read to you in its entirety. And this is what it says. Notice to all workers, employees, and employers regarding the voluntary nature of the IRS Form W-4. Internal Revenue Code Title 26, Part 31, Section 3402P-I, 26 CFR 31.3402P-1 provides that the IRS Form W-4 is a voluntary withholding agreement between an employer and employee. There is no law requiring a worker or employee to complete the IRS Form W-4. Employees who wish their employer to withhold state and federal taxes on income and for Social Security benefits and unemployment insurance must complete the IRS Form W-4, Employees Withholding Allowance Certificate, and give it to their employer. 26 CFR 31.3402P-I provides that the IRS Form W-4 is a voluntary withholding agreement that may be terminated by either the employee or the employer at any time by furnishing a signed written notice to the other. Employees who do not complete an IRS Form W-4 with their employers may not be eligible for unemployment benefits. You may not be eligible for Social Security benefits when you retire or become disabled if you fail to pay Social Security tax. Understand that although an employee may not wish to complete an IRS Form W-4, the IRS still requires an employer to request IRC 6109A3, the employee's Social Security number or taxpayer ID number. However, the employee may refuse to provide a Social Security number or TIN. An employer is prohibited by Title VII of the Civil Rights Act from dismissing any employee for refusing to provide a Social Security number or TIN number because of their religious belief or creed. There is no law requiring an employee to complete and submit an IRS Form W-4. Additionally, there is no law requiring an employer to accept an IRS Form W-4. Severe penalties may be applied against any person who, under the color of law, deprives another person of their rights. 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. This notice must be posted in a conspicuous place where it can be read by all employees and workers. See, that explains to them, and they can go look up the codes and understand the voluntary nature of the W-4 form. Now, in this, remember I told you that how civil rights are not what you want your unalienable rights. Well, in this particular case, I believe that this notice and this form, these forms are being used as yourself being a U.S. citizen and fighting it from that angle. And the reason why I say that is because, remember, even for a U.S. citizen, the income tax is voluntary. And you are simply wishing to unvolunteer for that tax. There's separate workings for sovereign citizens and U.S. citizens. And I just think that this is applying to you as staying as a U.S. citizen and using the civil rights as a U.S. citizen you have for, fighting back and protecting yourself. So that's the way I see it. Now, this is just the first half of the form. This is just a notice that you can give to the employer so they can read, they have something to read and look up the codes and understand the interpretation of those codes. Okay? And here's my whole thing and take on it. When an employer gives you a W-4 form and they put that in front of you, to me that is fraud. Because that's not the only form that they can use to give to you. And my question to them is this: are you working for the IRS? Are you being paid by the IRS Because why are you putting this form in front of me when there's other forms that may apply to me, but yet you're only providing me with this one? You're giving me legal advice on what I can and cannot claim and so forth. I've gone into fights with them because I've had them tell me what I can and can't do on that W-4 form. And I'm just like, well, isn't that giving me legal advice? That's not your job. So you're going to run into that, okay? And I'm going to get into detail on that in just a moment. The second half of this form, which is very important, is what we call the W-4T form. Voluntary Withholding Agreement, Termination or Withdrawal from the W-4 Agreement. What this is a public domain form. What does that mean? It means that it is not copywritten or owned by anybody. It's not an IRS form, but it is a legal binding agreement form that you can use in lieu of a W-4. Now, it looks just like, very similar to the W-4 form, okay? Now, I've had battles with my workplace telling me, well, our lawyers tell us that that's not a legal form, or they can't find that on any IRS form website or anything. Well, yeah, right, because it's not an IRS form. It's simply a binding public domain form that I give you legally, or can give you legally, because that's what the code or law says, that all you need is a certificate, a withholding agreement certificate form. It never says a W-4. It never says within the code, and I'll show that to you or explain that to you a little bit later, but it doesn't say that. So that, therefore, makes this a valid form. And I need to read this part to you because it's very important on that form. In lieu of W-4 employees withholding certificate, employer will not make any payroll withholding. Employee is responsible for all taxes. Now, if you have already given that workplace a W-4 form and you want to terminate it, this is what you do. You check that box. Termination of previous W-4 agreement, beginning effective on the last day of the pay period in intermonth or year. Okay? The next part says, I, Kevin Perteete, understand that termination or withdrawal of a W-4 employee withholding certificate releases the employer from any obligation to make payroll withholdings. Furthermore, I understand that I am responsible for all taxes due, and I release the employer from any tax liability associated with this employee. See? So simply stating, what you're doing there is like an affidavit of a hold harmless agreement with that employer. Hey, you're not liable. I am. This is why I'm filling this out. This is to stop all the taxes, and I take care of it if you have any problems. It's as simple as that. And down here it says for Social Security number, write none if you do not have a Social Security number, or decline if you do not wish to provide a Social Security number, because you do not need to give them one. There's no law that you have to. And personally, I don't like giving them one, because then they track you and trace you, and different companies can find out where you work, and like old debts come up, and stuff like that, and they come and track you at your work and start garnishing you at the state. I think it's a private matter where I work. Where I work at is my personal business, and no one else should have the right to know that. That's my feeling. But I'm not going to get all into that. I'm just simply showing you the forms that are at your disposal that you can use to exempt yourself from paying taxes out of your check. Now, there are fights, like I said, on this. It's the employer, it's them, not the IRS, who are taking the money out of your paychecks. Remember something. They're afraid of the IRS. They're not afraid of you. That's why they try to force this stuff, and they think that they're doing the right thing, or that it's the law that they have to, because they don't know the law. And like I've told you, lawyers for those companies do not know law. They know policy and procedure, okay? And that's the way it goes. And simply put, that's what you use to clear yourself and get yourself out of the tax system on that level. The next thing I want to say to you is this. If all else fails, and you feel pressured where you have to use the W-4 form, they tell you, well, if you don't fill this out, you're not going to get the job, and they say you have 24 hours to fill this out, or da-da-da-da, and I've gone through that too. What you can do is this. Go ahead and fill it out. Don't lose your job or not take the job because of that. Fight them at another angle. fill out the W-4 as you see right here. But you see on number 7, you're going to claim exempt to stop the taxes. Usually that stops the federal and the state, not the Social Security, Medicare, or SSI or whatever. So unfortunately, it's supposed to stop everything, but at the worst scenario, it'll stop the biggest and the third biggest tax out of your paycheck. On the bottom, it's very important. See how I made up a name, Mark Jones. This W-4 form is signed under economic duress and protest against my political and religious beliefs. Very important that you sign that at the bottom or something similar. Why? Because in the future, if you go to court and the judge sees that you did not sign anything, protest or objection on the bottom of your form, he's going to say, well, Mr. Jones, you're here in court because you're saying that you are not legally obligated to pay taxes and that the employer has no right to take it out of your paycheck, but you voluntarily, on your own will, they didn't force you, you filled a W-4 form out and you didn't put any protest remarks or any objection to it, so it's like, why are you here? What is it that you want the court to do? And there you go. And the reason why I'm telling you that is because it actually happened to me in that exact scenario, where I didn't put protest remarks, and then the judge is saying, well, what is it that I can do? You signed it. You agreed to the agreement of the form that have these withholdings, what have you, taken out. And you had no remarks. But now you see that I put these protest remarks. The judge now has to acknowledge, wow, this was signed under protest, and you provided the company with the codes, and now the ball's in the company's court or on their side. So why did you not adhere or acknowledge that he provided that with you and so forth? See, now you have a leg to stand on. Not that they're going to follow it, because they're in cahoots with the whole corruption or conspiracy of you paying taxes anyway. But it helps you and gives you a stronger leg to stand on than not putting those protest remarks down. That's why you do it, and that's the importance of doing that. So I hope I was able to help you understand the different forms and the different things that go on. One other quick thing I want to say to you is how people always say that taxes are mandatory, you have to pay them. That's impossible. It doesn't make sense. Why? Just on this W-4 form, you can make claims of different deductions, exemptions, and dependents, and adjust your taxes coming in and out and so forth. If taxes were mandatory, then we'd all be charged a straight out direct tax. Doesn't matter if you're rich, poor, kids or not, no kids, single. They would just take out a straight 25, 30%, whatever the case. And it's mandatory by law. This is what makes it mandatory by law. Here it is. When you work, everybody works. They just take out a straight percentage of money out of your check, and they provide you with the law that gives them the authority to do that. They don't do that, and there is no law, because if there was, they would have that, and that's why you can use these W-4 forms and other forms to exempt yourself and do different things, because it's not mandatory. All right, now I'm going to go back to me on the live speaking seminar and catch you back there.
All right, guys. Now, was that interesting or what, to show you the different forms that you use to have the taxes stop the taxes from coming out of your paychecks? Now, remember, it's your employer or workplace. It's them who have the power to do this. Like I told you, it's not the IRS, it's not the state. It's your employer that you're going to have to, butt heads with, and fight or, get them to stop taking the taxes out of the paychecks. So, that's the information, or that's how you do it. Now, I will tell you some true stories of butting heads with them. I've had the Human Resources Department say things like, I don't think it's fair that you're not paying taxes and I am, or that other workers have to pay tax but you don't. And I'm like, hello. I'm not doing anything immoral or wrong. I just simply learn the law and the application of it to stop the taxes. You can do the exact same thing I can do. I have no special rights over you. I'm just learning how to exercise them. So it's funny to me how the jealousy gets in there and how people, get all spiteful about it. Get the nerve up and learn it and do it yourself. Okay, so that's another thing that you run into. And like I said, if it gets down to the situation where you just don't want to deal with it, or you feel like it's just more than it's worth, then you just use the W-4 form, claim exempt, and write the protest remarks on it and be done with it. And I understand, and I've done it all. I've done it every which way. I've had it where, and I don't know if I mentioned this, but I think I did, but forgive me because I talked all these hours and I forget what I've said, but I think I mentioned to you about the payroll company ADP. They're a big payroll company here in LA. I don't know if they're nationwide, but they're very good with stopping the taxes coming out of your paychecks. And if you're lucky enough to have them doing your payroll, they know all this stuff. So, and they're really good at it, at least in the LA area. And the whole thing to this is like telling you, like lawyers and CPAs and all of them, they don't know the stuff. They don't know the law. They know policy and procedure. And many of them were trained by IRS agents. And government agents in the government on what they're supposed to do and take taxes out and misguiding them or teaching them not the full or the correct information. So you got to deal with that too. And that's what we're up against in a lot of cases. Now, I want to share something with you. It's a little bit despairing, but you have to know it, because this is what these people think of us. In the Corpus Juris Secundum, which is a encyclopedia of the United States law at the federal and state levels, this is what is said about us and about attorneys and clients. Attorney and client, his first duty is to the courts and to the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Wards of court, infants and persons of unsound mind. David Committee versus Lonely, 290 KY 644162. Clients are also called wards of court in regard to their relationship with their attorneys. That's what they think of us, as infants and as persons of unsound mind. I find that to be very offensive and disrespectful. But in many cases, it's true, because we don't learn the law and we don't apply it, and we let them walk all over us. That's why they feel that they can do that to us. Just a little bit of knowledge or information to share with you on that. And the next thing I want to say to you that's very, very crucial that you understand and important is that for those people who want to stay in the system, if you want your unemployment, your Social Security, etc., then you have to pay the tax and stay in the system. And there are many reasons why people will and do, and I'm not arguing that, and that's your own personal decision. My point is, for those people who do not want to be part of that and want no handouts or anything from the government should not be forced to have to pay the tax or be forced into the system of Social Security, etc. That's my whole point. Because I hear all this argument, well, the government's been good to me and I believe in the government, why should I? Well, then stay there. I'm not talking to you. I'm referring to the people, myself, definitely, that I don't want to be a part of the government. I don't want handouts. I don't want the government taking care of me. I want to be able to take care of myself. I don't want any part of this. And for all those who do not want that, that's why I'm doing this, and that's what this is for. to show you that. So I want that cleared up and understood as I'm closing this out. The next thing I want you to see and understand is that the codes and the different things that you see or that you heard and I read to you in those notices and so forth, and also too it's stated in there that if you want your unemployment and Social Security, then you must stay in the system and pay. So, but here it is. I took the time. This wasn't given to me. I took myself to the law library and sat there and found these sections of the IRC and U.S.C. codes and so forth and looked it up, and 6109 and the identifying numbers and supplying numbers, and read all of that and copied it down. The voluntary withholding agreements and the Internal Revenue Service Treasury 31.3402P1. There it is. Right there. You see some of the highlights of this, like, and stuff. I go and read these, and I encourage and advise you to do the same thing, so you're not just thinking that these people are just making up this stuff. It's there. It's in the law books. It's there. Go research. And this last little thing was during a court case. It came out as Exhibit A. I don't even remember the exact specific thing, but this ties in with that notice, 3402, employment taxes. Exemption certificates. On commencement of employment, on or before the date of the commencement of employment with an employer, the employee shall furnish the employer with a signed withholding exemption certificate relating to the number of withholding exemptions which he claims, which shall in no event exceed the number to which he is entitled. Nowhere in there does it say a W-4 form is the only, by law, mandatory exemption forms that you can use. The word W-4, it goes on. I mean, this is pages. It goes on. Not one time is the word W-4 mentioned that that's the only form that you can give or use. So that's where you have to research, people, and learn and read and understand what you're reading, or read between the lines and understand. It says nothing there about you can only use a W-4 form, which I've shown you that there are others. So I just want to share that with you, in closing this out. And also, too, the last thing I want to say is this. It's just come down to the point where when you exercise every right you can and you go to court and the judges are not following the law as it is written, that's when it's time to sue. That's where I'm at this point, is learning at this point the process of suing a judge, suing a police officer in court. I've never done it, but I need to learn how to do it, because that's your last avenue. And then that's when it gets into the whole talk about the militia and the people coming together to fight the foreign, the domestic, terrorism or tyranny of our government, which is where we are now, in my opinion. And this is where that comes from, because your courts are your last resort to restore your rights and your freedom. And when they refuse to look at facts and law and refuse to look at the 16th Amendment, all of the actual evidence that those gentlemen went around and show in 2 years of their lives to see that the 16th Amendment was not properly ratified, not even close. And then the courts are going to say that's a political issue and we can't deal with that or whatever. That's a bunch of BS right there. So that's where it's come down to. That's what we have to do. It's not fun, I agree. It's time consuming but it's a step or a hurdle that we have to jump over to free ourselves. So pretty much, I think that's it. I want to thank all of you for your time, and I hope that this seminar lecture workshop was very informative. You can leave comments. I would love to hear from you all. Share this with everyone. And I really have enjoyed, being able to hopefully teach and show you all new things and different things, and that it will be able to help you out in your own personal lives. And please share this with everyone. Please share this with your friends, your families, and co-workers, whoever. And with that said, keep the knowledge flowing so you can be knowing, growing, and showing. I am Kevin Perteete.
You want to hear this?
قدك ونشاك وهدالك جمال مفقود نعاتو ما كسبوه بنات جينك لا قرباك خلقك